It's matter. Your lordship directed me to serve copy, and your lordship fixed the date on 7th. I have done it, everything. My lord will remember, thrice we submit. I serve notice of, by direction of your lordship. But it was yesterday appearing, but my lord, we could not. 65 text macro. Well, I have been told, well, my lord, no date has been given for me. I have been told that একটু দেখে বলে দেবেন 65 ওটা ডেটটা কবে ফিক্সড হয়েছে আই এম গ্রেটফুল টেন্থ অফ ও মানে সেগ্রিগেটেড ওই তো মানে হবে হবে 24 I am grateful to you. I am sorry, my lord. I could not.
May I
It is yes, yes, yes. It is my matter is civil order, not religious.
May I be permitted to mention one matter for inclusion in the list on appeal, second appeal, my lord, 2000, my lord. Yes, my lord. Paper book is ready, my lord. Ready for hearing. Not filed, my lord, lying with me, my lord. It has not been filed. My lord, I can file, my lord. Yes, my lord, I am for the appeal, my lord. The erstwhile, my lord, advocate, my lord, died, my lord. That's why, my lord, that was not filed, my lord. The entire brief is lying with me, my lord. Now, no, with me. Yes, yes.
Madam, may I?
Yes, again, previously the respondent has been represented. My lord, after mentioning, my lord, I shall serve notice, my lord, the matter has been mentioned, my lord. Yes, my lord. Yes.
File the paper books, requisite number of paper books before the department, and upon the respondent also you provide
Then,
a
my lord,
copy of the paper book.
Next week, my lord, I have to serve notice this week, by this week, my lord.
My lord, I'm mentioning a matter for inclusion, my lord, second appeal, my lord. The paper books have been filed, my lord. I'm mentioning upon notice to the other side, my lord. The everything is.
You're for the appellants.
I'm for the appellant, my lord.
Ready for hearing.
Ready for hearing, my lord.
নিয়ে নিন
Order sheet.
আচ্ছা দাঁড়ান ওটা না ওটা আনিয়ে চলে লিস্টে দিয়ে দেবেন
Grateful, my lord.
There is no application pending.
No, my lord.
হিয়ারিং এ আসবে দেখে নেবেন দেখে নিয়ে হিয়ারিং এ আসবে আচ্ছা আজকে আইটেম নাম্বার 2 আইটেম নাম্বার 2 এর লাস্ট অর্ডার কোথায়
Well, I'm appearing for the opposite party numbers 1 to 4. My learned senior friend on the other side had more or less concluded their submission, and I was informed that only certain judgments were required to be cited. So
yes, Mr. Srivastava was appearing.
Yes. If my lord wants, I can start.
No, I'm wondering what is the correct time for commencing the hearing.
But 10:30 is good enough.
I was of the view
Yes,
it
yes,
is
yes.
10:30.
Because
But
that date was.
It is being changed. Nobody, not even a learned
Junior is there, yes.
At least the advocate on record should be there.
Yes, yes, absolutely.
ডিসপ্লে হচ্ছে তো
হ্যাঁ বাইরে ডিসপ্লে হচ্ছে
Okay. Let us start.
Yes, my lord.
They will provide the citations.
Right, my lord. আমাদের এই যে জাজমেন্টটা তো যেটা সুপ্রিম কোর্ট জাজ দিয়েছিল কালকে, এই দুটো দিয়েছিল তো, এর এক্সট্রা কপি আছে?
আপনার একটা
My lord, may I take up the responsibility of my learned friend? Yesterday, my learned friend provided us with copies of two judgments. I believe this is what they want to rely on. May I just hand it over, my lord, a copy of the judgments?
নিন
Both these judgments are on the point, my lord.
ওদিকে খেয়াল
As to
রাখবেন
দেখি
কি
copy দাও
করছে।
দেখি. If my lord sees the order of Maria Rickson and others versus Devashish Mullik. Item number 1 hai apni?
No, no, no.
Oh, acha, acha. If my lord sees the judgment of Maria Rickson and others versus Devashish Mullik, my lord will see from paragraph number 4 onwards at page 2.
Learned counsel, it will be better to submit as regards to the facts of the case.
Very well, very well. I'll do that. I've just
But,
handed over the judgments. Let them come and
Yet
place.
they have not filed.
They have not yet. They have not. Because I was served, I informed my lord. Now, oh, my learned friend is here.
Mr. Srivastava,
Yes,
you are relying upon
Your Lordship, just.
two citations. One is FMA 309 of 2026, Noor Hassan and another versus Hafiz Akhtar Ansari, and the other is FA 465 of 2025, Maria Rickson and others versus Debashish Mollik.
এই দুটোর উপর রিলাই করছেন তো স্যার? এই দুটোই সার্ভিস করা হয়েছিল।
Why 2-1? I gave him one reference. দুটো কোথায় দিয়া?
আমাদের উপরে দুটো সার্ভিস হয়েছিল স্যার, তাই আমি আমাদের উপরে দুটো সার্ভিস হয়েছিল, এই দুটো জাজমেন্টই সার্ভিস হয়েছিল।
No. I'm relying on Your Lordship, this one.
FMA 309,
Yes.
Noor Hassan.
The other one probably.
Other,
It is 465.
Yes. Maria Rickson.
FA 465.
Yes. Actually, paragraph 11 and 12.
Yeah, paragraph 11 and 12.
You are relying upon paragraph 11 and 12.
And 13.
11, 12, 13.
Especially, it is well settled that since the 1997 Act is a beneficial act and provides an additional clock of protection to the tenant, which is not otherwise available to them after cessation of contractual landlord-tenant relationship. The rigor of the said act are also equally applicable to tenants, in which what is given in one hand in the statute can be curtailed by the legislature. In view of the above principles, since it is an admitted position that the original tenant died in 2010, after expiry of 5 years thereafter, the status of the appellants being the heirs of the original tenant was demoted to mere trespasser.
That we were referring section 2G.
They do not come under section 2G, definition of a tenant,
After expiry of 5 years.
5 years. So the court ought to have, from the plaint itself, it was apparent that 5 years has elapsed. 2010, the tenant died. I accept what is there in the plaint. At this stage, Your Lordship, go. So, if can a trespasser be entitled to a injunction? Admittedly, they are not in possession.
They claim monthly tenant as heirs of deceased tenant. They are not claiming any independent right. The court completely overlooked that point. Both the courts below. And put him in possession.
Apart from this point,
The other point is, Your Lordship, from the pleading itself, pleading and the prayer was one thing, the injunction order was separate. There was no prayer for recovery of possession or for permanent injunction with regard to the possession itself. The pleadings and the prayer was that he went to lock the shop room, he was not allowed, and I should not alienate, the defendant should not alienate the properties, that is the machineries and others in the shop. That was the prayer. Nothing about possession. From the reading, Your Lordship, when Your Lordship reads the plaint, it is apparent that he was not in possession. Whatever may be the reason, the plaintiffs were not in possession for more than, Your Lordship, at least 14 to 15 years.
you have relied upon, not relied upon means you have only submitted verbally that they had surrendered.
That is for, it will go for evidence. What I have produced is genuine or not, it has to be tested on
Yes.
evidence.
Mm.
But prima facie, Your Lordship, I am on the pleadings.
Yes.
If
Apart
the
from that, we cannot go beyond that.
Beyond the pleadings, and the court cannot give them what they have not sought for.
Yes.
The court did not apply to that aspect of the matter. That the plaintiffs were even accepting what is there in the averments made in the plaint. The plaintiffs were admittedly at res judicata.
Yes. Apart from this judgment, any other?
This is
Yes, sir.
Supreme Court, Your Lordship, was otherwise with regard to the old act and the new act, which will take effect from when. The Supreme Court held that from 2001, when this act came into effect, that will be governed by the new act. Previously, 56 Act, Your Lordship, because under 56, the tenancy was heritable. So, a person who has died before this act came into force, the heirs inherited the property. So, once it has vested in the heirs, it cannot be divested by another act. That was the principle on which the apex courts decided that case.
So, এটা দিয়ে দিন, এইটা ফেরত দিয়ে দিন, এইটা দিয়ে দিন।
Yes.
Will be provided by you.
Yes.
May I commence my arguments, my lord? My lord, first submission is, my lord is exercising jurisdiction under Article 227 of the Constitution of India, which provides that every high court shall have superintendence over all courts and tribunals throughout the territories interrelation to which it exercises jurisdiction. My point is, my lord, this is not appellate jurisdiction. So unless there is patent illegality or there is an error in jurisdiction in passing the order impugned, my lords, usually do not interfere because my lord is not sitting in appeal over the order passed. So even if there are factual incorrectness, then also my lord should restrain my lord exercising the jurisdiction under Article 227. Now the second point, at what stage of the suit has the petitioner come before this honorable court? Now my lord, I am representing the opposite party numbers 1 to 4. My lord, we are the plaintiffs who filed a suit, a title suit number 70 of 2021 before Civil Judge Junior Division, 4th Court of Srirampur, for declaratory reliefs and for injunction. So, my lord, we filed the suit for declaration and injunction. Along with the suit, my lord, we filed an application under Order 39, Rule on 1 and 2 for interim injunction. An ex parte ad interim order of injunction was granted in my favor. Thereafter, my lord, I'll just give the brief background, my lord, so that the stage is clear.
Yes.
Yes. So, my lord, I had filed an application under Order 39, Rule 1 and 2 for interim injunction. The trial court passed an ex parte ad interim order of injunction on 5th of February 2021, granting me ex parte ad interim order of injunction. Thereafter, my lord, the defendants entered appearance. My lord, written objections were filed. Thereafter, upon contest by an order of 18th of April 2023, the ex parte ad interim order of injunction granted in my favor was confirmed and was directed to continue till disposal of the suit. Thereafter, my lord, the petitioner filed an appeal from that order granting injunction in my favor before the learned additional district judge, 1st Court at Srirampur.
The ad interim temporary injunction,
Yes, my lord.
order of ad interim temporary injunction is in which page?
My lord, I will just indicate the page. I have, my lord, annexed all documents to my affidavit in opposition. If
Yes.
my lord kindly takes
I've got it. In page 7980.
my lord. 79, my lord, is the, yes, my lord.
7980 of the, I think, affidavit in opposition, I think.
Yes, my lord. That is my affidavit in opposition, contains all documents. Page 79, my lord. So this is the first order, 6th of February 2021, when I got an ex parte ad interim order of injunction, my lord. This was subsequently confirmed by an order dated 18th of April 2023, which starts from page number 81. Now, this order, 18th April 2023, it disposes of multiple applications filed by the parties. So far as the injunction aspect is concerned, my lord will find that yes, my lord will find that from page 84. My lord will kindly turn to page 84. Kindly seize the penultimate paragraph on that page. Let the case record be taken up for passing order in respect of injunction application. Thereafter, my lord, discussion, reasoning, and thereafter at page 87, my lord, hence it is ordered that the ad interim relief granted to the plaintiffs to the tune that the defendants are hereby directed to not to dispossess the plaintiffs from the suit shoproom and or not to change the nature and character of the suit shoproom as well as the latch machineries and or not to alienate or transfer the latch machineries in the suit shoproom in any way or any manner is hereby made absolute till disposal of the suit. So, my lord, after contest, my lord, injunction was granted in my favor. Thereafter, my lord, they filed an appeal before the Honorable Additional District Judge, where, my lord, the impugned order was passed at which is at page number 123 of the same affidavit in opposition. This was an application in connection with the appeal for stay of operation of the impugned order. And, my lord, at page 123, the stay application upon contested hearing, my lord, was dismissed. From that order passed on 14th of November 2024, my lord, they have preferred this instant 227 application. Now, so far as one thing is concerned, in the appeal, their interim application for stay was dismissed, from which they are before my lord. Now, what happened to the appeal? It has been pending for more than 2 years. Kindly turns the page over to my lord, page number 125. These are the orders passed in the appeal. My lord will see that from 24th of January 2025, the appellant has been seeking adjournment on various grounds, including pendency of the application before this court. So today, the appeal has not been heard out on merit. The appeal is still pending. My learned friend's only stay application has been dismissed. Today in the appeal, the order may be affirmed. My lord, it may be reversed, set aside. Lot of things can happen. But instead of pursuing the appeal, my learned friend has chosen to almost like prefer a second appeal from the order granting injunction to me. So now, my lord, since my lord is sitting in 227, my lord, jurisdiction, checking the correctness of an order granting injunction in favor of me, then, my lord, the principles of prima facie case, balance of convenience, inconvenience, and, my lord, irreparable loss, injury, and prejudice, these principles would govern whether the order has been passed correctly or not. Only one thing, at the stage of ex parte ad interim order stage, after contested hearing, and even before the appeal court, my lord, at three stages, two different courts, my lord, have come to the same finding on facts and has protected me. Now, my lord will see that submissions are being made that I am not entitled to an order of injunction because I am not a tenant. My lord will see what is the dispute contemplated in the suit. Usually, my lord, what happens, tenant comes to the court, files a suit seeking declaration of their my lord tenancy rights. My lord will kindly see what is the scope of the plaint. The plaint which has been annexed to the revisional application, my lord, is the unamended plaint. Plaint was amended. I have annexed the amended plaint at page number 13 of my affidavit in opposition. Kindly see the scope of my suit. My lord, I'm sorry.
Page number?
My lord, page number 13.
Yes.
But before that, my lord, I just want to show two things from the petition itself. What is the main ground of challenge? If my lord kindly takes the petition once, the grounds would start from page number 11. This is the main, my lord, ground of challenge. Kindly sees, my lord, ground number 4. For that, the learned courts below passed the impugned orders of injunction without taking into consideration that the plaintiffs admittedly were not in possession of the suit room for more than 20 years and that by the impugned order of injunction, the trial court has changed the possession and status of the suit property. So, my lord, the principal ground on which, my lord, my learned friend's case stands is that I was never in possession, at least for 20 years. Same ground, my lord, will see in ground number 8, the next page. For that, the learned lower appellate court rejected the application for stay of the impugned order on surmises without considering the fact that the plaintiffs admittedly at the time of filing of the plaint and the injunction application were not in possession of the suit shop room. So that is the thrust of the case, that I was not in possession. Now kindly seize my plaint, my lord, from the affidavit in opposition at page number 13. Kindly seize whether the case that I have made out in the amended plaint, does it say that I was not in possession? Kindly seize the parties, my lord. 1, 2, 3, 4. There are 4 plaintiffs at page 13. My lord, all are the heirs of late Devaki Sharma. Plaintiff number 1 is the wife of late Devaki Sharma. 2, 3, and 4, my lord, are all sons of late Devaki Sharma. Now, my lord, will see the defendant numbers 1 and 2. Haril Sharma, alias Horil Sharma, Om Prakash Sharma. My lord, Haril Sharma was the brother of Devaki Sharma. So, my lord, the uncle of the sons. And my lord, Om Prakash Sharma, my lord, is the son of Haril Sharma. As on date, Haril Sharma has passed away. And my lord, only Om Prakash Sharma is there. Now, defendant number 3 is my lord, Sanjay Jhunjhunwala, who's my lord, my learned friend is representing. Kindly seize, my lord, I will just show a few paragraphs from the amended plaint. Kindly seize, my lord, paragraph number 1 onwards. The plaintiffs herein are the legal heirs of late Devaki Sharma, being Dharmabhuti Sharma, wife of late Devaki Sharma, Bharat Bhushan Sharma, Kamal Sharma, and Manoj Sharma, being the son of late Devaki Sharma. On or about September 1982, a tenancy agreement was entered into between one Madan Lal Jhunjhunwala, son of late Anandran Jhunjhunwala, and late Devaki Sharma, son of late Aklu Sharma, with regard to one shop room measuring 17 feet into 12 feet, situated on the western side of the boundary of premises under plot number such and such, Dankuni, district Hooghly. So, my lord, Devaki Sharma was admittedly inducted as a tenant. I have annexed a copy of the tenancy agreement. This is not in dispute. Now, my lord, this Madan Lal Jhunjhunwala has passed away who is the father of Sanjay Jhunjhunwala, defendant number 3, whom my learned friend is today representing. Now, my lord, by dint of the said tenancy agreement, the said Madanlal Jhunjhunwala had kept a security deposit of rupees 3,400 for such tenancy, and in the year rupees 250 as monthly rent was fixed with regard to the said premises. At that juncture, the wife of late Devaki Sharma was housewife and the sons were minor. Now, my lord, Devaki Sharma used to do business on and from 1982 from the said premises of welding of different materials. Slowly and steadily in the year 1999, Devaki Sharma started his business of lathe by purchasing different materials from one DB Machine Tools. The said Devaki Sharma had purchased the said machineries from DB Machine Tools of one Bidhan Sharoni inter alia as follows. Then, my lord, particulars of those machineries are given. Paragraph 5 talks about the cost of the machineries being around 1,63,000. Now, my lord, will read from paragraph number 6. Your plaintiffs state that on or about 2000, the said respondent number 1, Haril Sharma, alias Haril Sharma, who approached the father of the plaintiff numbers 2 to 4 and the husband of plaintiff number 1 to do some supervisory work under him. Your plaintiff states respondent number 1 used to do supervisory work under the husband of plaintiff number 1 and father of plaintiff number 2 and 4. At that juncture, plaintiff number 1 was a housewife and plaintiffs 2 to 4 were minors. The father of plaintiff numbers 2 to 4 and husband of plaintiff number 1 had a trade license in the name of Sharma Engineering and Wires. So, my lord, late Devaki Sharma had a trade license in his name. He was the proprietor of the business. He had engaged Haril Sharma for doing supervisory works under him. I have shown the language. Paragraph number 8. The plaintiff state late husband of plaintiff number 1 and the father of plaintiff numbers 2 to 4 died on 7th of January 2010. After the death of the husband of the plaintiff number 1 and the father of the plaintiff numbers 2 to 4 and opposite party number 1,
Counsel,
my lord.
At the time of hearing, you had provided a power of attorney and an annexure D being family settlement.
My lord, annexure D is, my lord, death certificate. And my lord, annexure C is trade license. My lord, I am reading from the plaint at page 16 of the opposition, my lord.
Yes.
My lord,
C is trade
annexure
license.
C is trade license, my lord.
Along with
Annexure D is, my lord, death certificate. Because, my lord, Devaki Sharma, my lord, passed away on 7th of January 2010.
Have you not provided any power of attorney and family settlement?
My lord, I meaning the wife and the 3 sons.
Yes, yes.
No, my lord. Wife and the 3 sons. I'll tell you, my lord, what had actually happened. When Devaki Sharma, the record.
Documents did you rely upon?
My lord, I relied upon trade license. I relied upon death certificate. I relied upon, my lord, the annexure number A being, my lord, the tenancy agreement.
Trade license, in which
My lord, I have annexed all the trade license. My lord, will kindly come to, my lord,
the last
page
one?
number 135. Kindly seize, my lord, page number 135. I have to show that I was always in possession, which is one of the biggest contention, my lord. I have annexed, my lord, the electricity bills issued by West Bengal Electricity Distribution, my lord.
I'm not referring to the electricity bills.
My lord, the trade license is also here, my lord. We'll kindly turn over a few pages. My lord will see, trade license, page number table ball.
Electricity bill.
My lord, page 143.
Electricity bill is in name of Dharmavati Sharma.
Yes, my lord. Plaintiff number 1, which is opposite party number 1 before, my lord. So I had
143.
Yes, my lord. 143 is the permanent certificate of enlistment, my lord. We refer to as, my lord, the trade license. The Board of Councillors of Dankuni Municipality hereby grant unto, my lord, Dharmavati Sharma. So after late,
Can we see the date
the date is of 16th of February 2025.
after the suit?
My lord, the husband, Devaki Sharma, my lord, passed away. The business was named in the name of late Devaki Sharma. With the plaint, my lord, I had annexed, my lord, the trade license of late Devaki Sharma. And now, my lord, after the death of Devaki Sharma, Dharmavati Sharma, the wife. What I want to show is that
During the interregnum period between 2010, after the expiry of Devaki Sharma,
yes, my lord.
and till the filing of the suit,
My
have you
lord.
produced any document apart from?
No, not
the bills?
apart from this, no. But if my lord wants, I can provide the trade license, my lord. From after the death of Devaki Sharma, the name of the
Not
business.
been provided during the ad interim temporary injunction.
So that yes, we did not provide, but
We cannot be.
it should not be considered by my. That is why, my lord, I have not annexed them. I did not want to annex new documents. So what I'm trying to say is that, my lord, the business was always in the name of late Devaki Sharma. After Deoki Sharma, the business was transferred in the name of his wife Dharmavati Sharma. And Deoki Sharma had asked for help from Horil Sharma, the defendant number 1, that you do supervisory work under me. If my lord, if we can come back to the plaint once now. May I come back to the plaint, my lord? Yes, my lord.
In page number 140,
My lord.
you have provided electricity bill. Page
140 is electricity bill, my lord. Yes.
1 electricity bill. And yes, 140 and 141.
Yes, my lord.
For the year 2017.
Yes, my lord. Deoki Sharma had passed away, my lord, but the name wasn't changed. My lord, will see it's mentioned Dayaki, it should be Deoki. But my lord, this happens when the electricity connection is not changed after the death.
Deoki Sharma.
Yes, my lord. That's the predecessor in interest of the plaintiffs, my lord, the original tenant in whose favor, my lord, the tenancy agreement was there from 1982.
No, apart from the name of Deoki Sharma,
My lord.
the name of Dharmavati Sharma,
Yes, my lord.
from any document will it reveal that it has been converted in the name of the sole proprietorship firm?
My lord, the last
Proprietor-
annexure, my lord, that trade license, my lord,
Trade license is dated 16th
2025 years, my lord. No,
2025.
apart from this, my lord, no other document. But no other document has come from anybody else also, that during the period from 2010 to 2025, somebody else was running the business, or there was a trade license in the name of somebody else.
Correct, counsel.
Yes, my
Let
lord.
us go to the injunction, temporary injunction order.
My lord, I will. Kindly allows me to place a few more paragraphs from the
The
plaint.
question is, which documents were considered?
My lord. Then my lord will kindly come to, my lord, page 38 of my opposition, where the injunction application is there. Page 39, my lord, it begins. My lord will come to page 40 directly. I had relied on the tenancy agreement, my lord, in paragraph number 4. On or about September 1982, a tenancy agreement was entered into between one Madanlal Jhunjhunwala, son of late Anandran Jhunjhunwala, and late Deoki Sharma, son of late Aklu Sharma, with regard to one shop room measuring 17 feet into 12 feet. So, my lord, the point when I entered into possession,
Since September 1988 till
80
the death of, sorry,
did
82,
yes, my lord.
82 till the death of Deoki Sharma, that
My
is in
lord.
2000 or 2001.
2010, my lord.
2010.
That is mentioned in paragraph number.
2010, when Deoki Sharma expired.
Yes,
This
my
is-
lord.
This is one period.
This is one period, yes.
During this period, the tenancy agreement.
Yes,
kept
my lord.
tenant,
Yes, my lord.
unless and until he has surrendered or evicted.
My lord.
No, both
My-
have not taken place.
My lord.
Thereafter,
Thereafter.
after the death of
My lord.
Deoki,
Yes, my lord.
second stage
Yes,
comes
my
into
lord.
play.
Yes, my lord.
So within this, after the death of Deoki and till the filing of the suit,
Yes, my lord.
any document which you have relied upon?
I'll just see, my lord. Xerox copy of the death certificate is there, my lord. And I had lodged a police complaint, which is at page number 45, paragraph number 22, that is annexure E. এছাড়া আর অন্য কোনো document দেওয়া হয়েছিল? কোর্টের কাছে করেছে। And my lord, I have been instructed by way of my lord Firisti, my lord, we had deposited certain electricity bills during that period. This is my instruction, but it's not annexed to the injunction application. But my lord, the only thing that I want to show is that today, my lord has to come to a decision as to whether or not I was in possession. Then only my lord will protect my possession by way of injunction, which the learned courts below have done. That is why I wanted to show, my lord, that my point of coming into possession is undisputed 1982 tenancy agreement. Till Deoki Sharma dies, I am Deoki Sharma continued. Now, what happens, that is why I was showing the plaint, my lord. In the plaint, I have narrated that after Deoki Sharma died, the sons were minors, she was a housewife. they couldn't run a business. So, my lord, what they did, they brought in Haril Sharma to run the business on their behalf, supervise. So, my lord, I was always in possession. If I bring in a manager in my shop, my lord, does that mean that I have transferred the possession to the manager? No. Haril Sharma was managing and supervising the business. The business was always with me. And the fact is that even in 2025, I was shown trade license, the business is in my name. Now, my lord, what it has been argued is that admittedly, I was not in possession. I want to show that there is no admission whatsoever that I was not in possession. In fact, on the contrary, I have stated that my possession was disturbed.
There is one more suit pending apart from this one.
No, my lord, no other suit pending. No other suit pending, my lord. This is what I also.
I have seen.
Yes, my lord, I'll indicate, my lord.
Why Horil against them?
My lord,
To
that is not
for
pending.
protection of his possession.
May I indicate, my lord? I'll clear the doubt. Today, my lord, the entire suit I had filed because after I brought in Haril Sharma to supervise the business, Haril Sharma decided to use up the business. Initially, they would pay us monthly 7,000 to 9,000 rupees, on which, my lord, my family would run. Thereafter, he stopped paying the money and he said, no, this is not your business, this is my business. And then Haril Sharma filed a suit. I also filed a suit, my lord, saying that this is my business, you are merely a supervisor, I am seeking declaration and injunction against you. My lord, thereafter, Haril Sharma and I, we had some differences. We sorted it out, my lord. Haril Sharma withdrew his suit. That is why I submitted, my lord. There is no other suit as on date. Haril Sharma and I, whatever differences we had, my lord, we have sorted it out. He initially instituted a suit, but he has withdrawn it. May I just show the scope of the suit once more, my lord, if my lord kindly comes to the amended plaint once.
No, that is not required. Let us go to the injunction petition.
Yes, my lord. Kindly page 38, my lord. It begins. From the injunction petition also, my case would be clear, my lord. I have already placed till, my lord, paragraph number
38 is the
38.
yes. Injunction.
13 is the amended plaint, my lord. Injunction application begins from page 38. Now, if my lord kindly comes to, my lord, paragraph number 11 at page 42 of the injunction application.
Used to pay 7,000 to 8,000.
Yes, absolutely, my lord. Used to pay me 7,000 to 8,000, but from paragraph number 12, the respondent number 1 was running the business unlawfully of the petitioners herein out of the form of the petitioner. After 7th of January, my lord, the person dies, my lord, people change, and latter machineries of the petitioner. The petitioners being the owners of the said business, I'm saying that I'm the owners of the business, was deprived from being paid a single penny. Respondent number 1 continued to use the lat machineries and the business whose owner are at present the petitioners herein. The said business cannot be run illegally by the respondent numbers 1 and 2 continuously. The petitioners being the owner of Sharma Engineering Works situated at Delhi Road, Chowmatha, Honorable, Dag number such and such, intends to close down the said business. Paragraph 14. The petitioners state that the petitioner numbers 2 to 4 on or about 13th March before the COVID-19 lockdown went to the said premises and tried to put a padlock on the said shop room. It is my shop room, my tenancy. I tried to put a shop room. I tried to put a padlock on the shop room. The petitioner states that when the petitioners tried to put a padlock at the said premises, immediately respondent numbers 1 and 2 in connivance and conspiracy with respondent number 3 tried to resist the petitioner. The said respondents further threatened the petitioners with dire consequences of life. The petitioner states that as on such and such, also the petitioner tried to put a padlock on the said premises, thus closing down the said shop room. This averment, in my most humble and respectful submission, my lord, I would say is, my lord, the defendant numbers 1 and 2 in connivance with defendant number 3 attempted to disturb my possession. I had the lock, I had the key, I was not allowed to put it. So, my lord, my allegation is my possession was being disturbed. It does not say I was not in possession, I tried to get into possession. Paragraph number 15, my lord, petitioners declare that they are the owner of Sharma Engineering Works. Under no circumstances the said respondent numbers 1 and 2 forcefully and or illegally, unlawfully be permitted So I am saying it is my premises, this tenancy, it is my business, and you are not giving me any money and you are running my business. That is not permitted. That is my allegation in paragraph number 15, where I sought that they should not be allowed to illegally or unlawfully be permitted to run the business and earn profit from the business of the petitioners. The law of the land does not permit the respondent to carry on unlawful business with latch machineries of the petitioners. Thus, at both the instances of 29 November 2019 and thereafter on 13 March 2020, when the petitioners went to take custody of the own machineries and shop room of the said respondent numbers 1 and 2 in connivance and conspiracy with respondent number 3, tried to resist the petitioner numbers 2 and 4, and they also used filthy language to the petitioners and threatened them with dire consequences. Petitioners did not have any alternative, that due to lockdown, the petitioners could not take steps. But after getting a slight pause from COVID-19, the petitioners had immediately written a complaint to the officer in charge of Dankuni police station about the facts and circumstances under which the respondents forcefully resisted the petitioners from putting padlock. So this gives me the cause of action, my lord, resisting me from putting the padlock on my own tenanted premises. Petitioner states that even after instituting such proceedings, the said respondents are illegally carrying on business from the said shop room. The petitioner states that the said respondents are also connected with some antisocial elements and such. My lord, thereafter the usual, my lord, paragraphs.
Apart from tenancy agreement, Annexure A,
Yes, my lord.
invoice of purchase of the machineries,
My lord, to show that the machineries were purchased by me in my name.
Annexure B,
Yes, my lord.
trade license of the dated of the year 2025.
Just one moment, one moment, my lord. This trade license was not of 2025 because this my lord will see that the title suit is 70 of 2021. So this trade license, my lord, which has been mentioned as annexure number C, my lord, is a previous trade license. My lord will kindly come to page 42 once.
Yes, 42.
Yes, my lord, see the copy of such trade license in the name of late husband. So this is Devki Sharma's trade license, not Dayavati Sharma. What 2025 I showed was Dharmavati Sharma's.
Husband of petitioner.
So this trade license that we relied upon was of Devki Sharma. So my lord, that is the husband of petitioner number 1. That was relied upon, my lord. D is, my lord, the death certificate of Devki Sharma. And my lord, E is, my lord, the
Not supposed to give a legible copy of that trade. license.
we have brought typed copies and legible copies, my lord. And my lord, annexure E is the
Legible copy was not supplied.
Copy of
That trade license and the documents, your lordship will see, it's black, completely black, the annexes.
Yes, yes. I will show, my lord. Kindly comes to, my lord, the
You were supposed to hand over
yes,
legible copies.
Kindly sees, my lord, the trade license that we are talking about, annexure C, my lord.
Learned Counsel, have you not annexed all the documents?
Yes, my lord. I will show, my lord, from I'll indicate, my lord, injunction application. The first annexure, my lord, is the tenancy agreement. That, my lord, will find from page number 49.
Yes,
This indenture is made this such and such date of 1982 between Madan Lal Jhunjhun. So, my lord, this is the agreement, my lord, which
legible copy of that tenancy agreement.
And then
yes, my lord, I have a legible copy of the tenancy agreement. If my lord wants, I can also hand over a copy to my learned friend. This is an undisputed document.
Court doesn't have the legible.
I am providing, my lord.
we don't have also.
My lord sees this is the sir. Tenancy. I have handed over a copy to my learned friend as well.
This one is the annexure.
This is annexure A to the injunction application, my lord.
Yes.
And this is at page numbers 49 to.
Yes. Annexure A.
Yes, my lord. 49 to 55 of the opposition, my lord, is what I have handed over. Then, my lord, page number 56 is legible. Yes, my lord.
The entire, all the documents are here. Okay.
Yes, my lord. All the documents I will take, my lord, one by one.
Only the agreement is there. The others are not.
Sir, I have it.
They have provided page 60. Page 60 is the death certificate. Annexure B.
Yes, my lord. That is the death certificate. Even that I have a.
Is that annexure B?
Yes, yes, my lord.
Can we give a legible copy?
No. That is annexure D.
D, my lord. Annexure B, my lord, will find at page number 56, my lord. That is the legible copy. Number 56, legible.
That is there.
Page 56 is legible, my lord. Annexure B. This is the, my lord, the invoice for the latter machineries. Has my lord found it? 56.
Then,
I have given a copy, my lord, to my
Oh.
learned friend.
what is your learned advocate on record doing? We will go through the pages. No. Legible, 55. You have reached 55.
Yes, my lord, 55.
Thereafter, no. After 55, 60.
Yes, my lord, because my lord, page 56 was legible, my lord. We did not provide this, my lord. Page 56 is legible from the opposition, unless, of course, my lord wants, I can provide a. 56 is there, my lord.
No.
Page
but,
number 57, my lord, is the.
When you are providing,
I should provide
the-
all.
Provide the entire.
Yes, I'm extremely sorry. তোমার উচিত ছিল সব কটা একেবারে করা। তুমি শুধু ওই
57 is not legible. Annexure
50, yes,
C.
57, my lord.
Annexure C, trade license,
The
this one
key.
is not legible. Lord Counsel,
My lord,
kindly provide all the annexures.
I will provide all the annexure. এটা legible
All
copy
the
কোথায়?
annexures during the course of this day.
I will do it immediately, right now, my lord. এটা দুটো ইনভয়েস। এটা annexure C হচ্ছে trade license. Where is the trade license? Sure. Right. Annexure C is the trade license and annexure D is the death certificate. My lord, annexure B is the invoice. D is the death certificate. Now, my lord,
BT Road.
may I show the?
Top.
Yes.
Annexure B is an invoice where the machine was ordered at BT Road. GT Road,
57 টা কোথায়
GT road.
not this premises, not for this
page
premises.
number এটাতে তো 60 লেখা আছে।
Belongs to Deokish
দুটো কি এক-
Yes,
Sharma.
that is
Sir.
there. I'll come to everything. Let him please,
Because
because
year
the-
1999.
yes,
তোমার এখানে
It
কি
happened.
পাচ্ছে?
Your Lordship, I'm not disputing. Only I wanted to see the legible copy, then I'll make my submission.
My lord, this is my কত date 19. This is, my lord, the trade license of Devki Sharma, my lord, which we had filed before the, my lord, annexure C to the injunction application. Yes, sir. Yes.
Kindly see the date of it.
So, my lord, this is the Devki Sharma's, my lord, trade license that we had issued by the Gram Panchayat, my lord, that we had submitted before the learned court below.
Nineties.
One is dated 1/12/1990,
Yes, my lord.
the second one, and the
Yes, ma'am.
first one dated,
31st December.
no, written in Bengali, not
Yes.
not English.
Right.
11th, I think 11th of December.
Yes, my lord.
What is the year? For the period 85-86.
He was in possession at that point of time.
No,
There is no
Yes,
dispute
yes.
with
there is
regard to-
there is no dispute till 2015.
No, 2000, till 2000. My case is till 2000 he was there. Then he surrendered and transferred to me.
Yes, this
Oh,
I want to
that is
address.
So, Your
To
Lordship,
address.
all previous documents,
But you could not provide any surrender agreement for surrender. Or
yes, that is annexure I have given. That agreement was there. That I have placed that agreement. It is
Agreement for-
authentic or not?
agreement surrendering the tenancy.
Yes, and
Annexure, which annexure? Which annexure?
kindly come to Your Lordship. Supplementary affidavit,
Supplementary affidavit. দেখাও কোথায় supplementary affidavit.
kindly come to supplementary affidavit.
Yes, supplementary.
My
Number is
page
supplementary
5 onward.
page. The page.
That is authentic or not, it is to be taken at the time of every time.
5th of March 1999. Key, এটা কি?
Your Lordship has got that.
Yes.
That
Was
he
this-
surrendered and they told me to give it to his brother.
Was this agreement provided to the trial
Yes,
court?
it was referred to.
Subject to correction.
Has it been dealt?
No,
Anyway-
nothing. Nothing has been dealt.
No. If it has not been dealt, then Learned Counsel, have you provided any written objection to the
Yes, yes, that is there.
temporary
Written
injunction?
injunction.
Which page?
Yes.
My lord takes my affidavit in opposition. I have annexed the written objection at page number 73.
And in which paragraph you are referred to?
Yes. Kindly come to
Page
73, my lord.
73. Yes, 73.
take the written objection of defendant number 1 and 2 and my written objection.
No, I am
This-
referring to the written objection filed by your client,
Yes,
Number 3.
defendant number
3.
3. In which page?
Yes. Kindly come to page 73
No, 73 is of
of
the-
his
uh,
opposition.
yes, defendant number 3. Which paragraph?
Seven onwards, your lordship will kindly.
In which, wherein you have specifically mentioned the- about the surrender, and has that been provided as an annexure?
I believe, my lord, it is mentioned in paragraph number 11, but there is no annexure. At page 76.
Yes, we have referred to that. Specifically to that agreement.
There is no reference to any agreement. It
Yes, amicable agreement
amicable agreement.
between the plaintiff's predecessor and his brother.
And defendant number 1 took possession of the suit property on full knowledge and free consent of all in the year 1999. Defendant number 1 has been running the business of such and such,
That is between the brothers, that
The-
is between the that family,
my lord.
Yes,
Sharma family.
the elder brother surrendered, told me to induct his younger brother. We inducted the younger brother.
Can you provide, have you provided any rent receipt in the name of any other person apart from Devki Sharma?
Huh? It's not here, but I can provide.
Not before the trial court, my lord.
No,
Before the trial court, but
I provided
now.
the agreement.
which agreement?
That agreement I showed, and I've referred to
Wherein
specific.
it is mentioned that it is annexure.
It's not annexed, but it has been referred to. Your Lordship, but in the trial court at the time of hearing the injunction, by Fristi, the documents are filed.
Hmm.
Your Lordship knows
If-
that. By
If at
Fristi.
all, we take into consideration that it was filed through Firistry, not mentioned herein, but that ought to have been discussed in the order.
Nothing has
Has
been
been
discussed. The court has not discussed anything.
My lord,
How
two
can-
courts.
How can this court consider?
Because your Lordship will see from the order itself, the death of the original defendant, tenant not referred to, when it is mentioned specifically in this, in the plaint and the injunction application. It was, that aspect was not at all considered. Mechanically, because a suit has been filed, so an injunction has to be maintained. But your Lordship will kindly consider. The trial court has to maintain the position that was on the date of filing of the suit, when admittedly the plaintiffs were not in possession. Then how can that be put into?
According to you,
They changed the
that point.
situation. What was there at the time of filing of the suit, that status and circumstances has been changed by the order. That cannot be. Injunction is to protect the property as it was on the date of filing. By this interim order, it may be that Horil was as a supervisor, but as per the plaint, Your Lordship, they said that he was not allowed to put the padlock. That means he has been ousted. It means that. And who ousted him? The defendant 1 and 2, in conspiracy with 3. 1 and 2 were Horil and his son. Then what is the meaning of that? He was not allowed to put a padlock, and he was threatened and driven out. That is his plaint case. Your
according
Lordship,
to-
specifically.
according to the landlord, Horil was in possession
Yes,
at that point of time.
yes. And they, and
One minute.
kindly see,
One minute, Lord, no.
paragraph 10 of the
In
plaint,
this regard,
specifically,
has the opposite parties number 1 and 2, the Horil and his son,
My lord, Horil has passed away. His son is opposite party
No.
number 6, I
at
believe.
the time of hearing of the ad interim or temporary injunction,
Yes, my lord.
was Horil present, alive?
yes.
Or
Horil was alive
Yes.
when the trial court order was passed. He passed away subsequently.
so
And what
have-
defense he has taken, Your Lordship, that is there?
have they filed any written objection to
Yes.
the injunction application?
Yes, my
Yes.
lord. That my lord will find at page 69 of my opposition.
69. What
Kindly,
stance they have taken?
that they are in possession? Sixty-nine.
Mr. Srivastava, let
Oh,
the adversary
yes,
get the
my-
opportunity.
Yes.
Yes, what stance they have taken?
They have taken their stance earlier was that they were in possession.
No.
Paragraph 2 at page 69.
Through this written objection.
69 paragraph 2, my lord.
Paragraph 2. yes.
Different numbers 1 and 2 are in possession of the suit property for a long time, and the petitioner defendant is earning his livelihood therefrom. The plaintiff, being jealous, are trying to disturb the smooth running of the business by the petitioner defendant. So I say my business, they are disturbing my possession. They said that it is their business, and I am disturbing their possession. Same allegations two brothers
But-
had against each
But
other.
this Haril and neither Haril nor his son Om Prakash
My lord.
Om Prakash could provide any rent receipt or anything.
No rent receipt, no trade license also. How are they? It is their business. And my lord, I will show the connivance between Haril, Om Prakash, and my lord, the defendant number 3 right now, my lord. My lord has seen that there are two principal objections by the petitioner. Number 1, in 1999, I had surrendered my tenancy. The original tenant, 1999, surrendered a tenancy. That document is also, although not there in, my lord, before the trial court, even then I am addressing it.
1 minute. What is through the written objection filed by the defendant number 3?
My lord,
they have-
73.
What they have stated as regards to possession?
Yes, that my lord will kindly come to my lord, page number 76, paragraph number 11.
Yes.
Fact remains that the defendant was shown an amicable agreement between the plaintiff's predecessor and his brother Deoki Sharma, who are full-blooded brothers, by which the defendant number 1 took possession of the suit room on full knowledge and free consent of all in the year 1999. So according to the petitioner, the opposite party number 5 and 6 took possession in the year 1999.
The Horil and his
Yes,
son.
yes. So according to them, In 1999, I was dispossessed. That is why, my lord, 20 years I am not in possession. How can I get an order of
According to them, Horil and his son,
1999, they took possession.
at the time of filing of the suit, were in
I was
possession.
not in possession.
You were not in possession. Horil
Horil and
his
Om Prakash was. And my lord, not only that, it is not only about possession.
Mr. Srivastava,
Yes,
according to you,
yes.
Horil and his son
Son,
were in possession.
they were in possession.
But Horil, neither Horil nor his son could provide any document in support of their contention, in support of your contention.
Either rent
No,
receipt
they
or trade
stated
license.
or not.
Huh?
They have stated or not, that has not been controverted.
Documents?
They must have produced. It's not for me. But admit, Your Lordship, the plaintiff admits in his plaint that Horil and Om Prakash is in possession. That is paragraph 10 of the plaint.
Learned counsel, clarify this point.
Yes. That
Paragraph
is why
10
I
of the-
wanted to show the plaint.
This point.
My lord kindly comes to the plaint. That is why I wanted to show the plaint. It begins at page 13.
In the injunction application also it will be there.
Yes, but plaint, my lord, is my. I will show the reliefs also.
Whatever you think.
Kindly seize, my lord. Paragraph number 9. What is the meaning of this sentence? At page 16, my lord.
Yes, paragraph number 9.
After the death of the husband of the plaintiff number 1 and the father of the plaintiff numbers 2 to 4 of the opposite party, opposite party number 1 used to supervise our business. This, my lord, opposite party number 1 or the defendant number 1, my lord, is Horil Sharma. So I have stated he used to supervise, kindly marks the portion, our business. Thereafter, his son Om Prakash Sharma used to supervise the business of the plaintiffs. Thereafter, a monthly payment of 7,000 to 8,000 supervisory such business. Thereafter, was stopped completely. Now, thereafter, my lord. Yes, paragraph 11. The plaintiff, second line, my lord, the plaintiffs being the owner of Sharma Engineering Works situated at Delhi Road, Chaumatha, such and such, intend to close down the business. So everywhere I am saying it is my business and I have given it to them for supervising. It is almost like bringing in a manager or a supervisor. That does not mean that I have given away the possession to third party. And my lord, I also want to show 2 more documents. Those documents were not there, I think, before the trial court. But it is important because 99, then my lord will not take judicial notice of the 99 document.
No more document can be taken into consideration which were not provided before the trial court.
Very well, my lord.
Your Lordship,
May I show pleadings then?
Your Lordship, may I, sir? Documents were filed by Horil in the court below by Christie
If
at the
those
time of
have-
hearing of the injunction
if
application.
those have not been considered or mentioned in the judgment, in the order,
I will get the
in the order.
certified copy of those documents which have been filed.
if those have not been considered in the order passed by the while passing the ad interim temporary injunction
Yes.
or temporary injunction. If
Temporary
those are
injunction. At interim, the defendants were not there.
not there at the time of temporary injunction, if those were not considered and those have not been mentioned herein, they won't be taken into consideration.
I'll place it on record because those were filed by Christie, by defend. I have just got the instruction.
Learned counsel,
By Christie, it has
Cannot be
been
taken-
filed before the trial court.
cannot be taken now.
No, it is on record of the trial court. I'm not producing it. It is on record in the trial court. That has not been referred to. It is on record of the trial court. If the court doesn't mention it, what can the client or the advocate do? If that document is there before the court. I'll get the certified copy if your lordship requires.
By
Because
which-
those are part of the record.
counsel, by which order? By which order?
By
By which order?
At the
It is
time of
mentioned.
hearing of the injunction application, those documents were produced by Horil. His trade license, rent receipts, everything. By Firisti.
You must have provided the order sheet also.
Yes.
Yes, that order, that is not the entire order sheet. But on the 18/4, all the orders are provided.
Yes, 18/4.
That is my grievance, Your Lordship.
In which page number?
So many orders were passed, matters were taken up together. 18, Your Lordship will come the certified copy. Your Lordship may kindly call for the record, I'll put in the special messenger.
My suit will get delayed, my lord, if LCR is called for.
You have the injunction.
You are in
What?
possession.
You have the
I am in
injunction.
possession, but I
You have
don't want
got
the
into
suit.
possession.
Very well, my lord. I am not objecting there.
Which page? Which page?
The certified copy.
Yes, internal page.
For what?
Yes, you can place the certified copy. Which paragraph or which page do you intend to place?
It has not been referred to. It has not been mentioned in any of the orders. That is my given. Your Lordship will kindly take up internal page 4, where he has
Hmm.
kindly see, Your Lordship, page 5. During hearing, penultimate paragraph, Your Lordship will see. Learned or defendant has filed photocopies of the rent receipts.
During hearing, the learned advocate for the defendant. Defendant.
He was referring to 1 and 2. And then he refers to my defendant number 3. Rent receipts were filed. And also the trade license, Your Lordship, that has not been referred to. I can get the certified copy from the trial court. Of trade license in the name of HON'BLE.
Suit is pending before which court? Srirampur, Hooghly.
Yes, my lord.
Your Lordship, I'll put in the special messenger. One day it will come.
May I proceed, my lord? Or my lord wants to call for the LCR?
The learned senior counsel further commences his submission. And refers and complete the same and refers to a judgment of this honorable court passed in FA, first appeal, FA 465 of 2025. Full stop. Paragraph. After the completion of the submission by the learned counsel representing the
Petitioner, my lord.
petitioner,
Petitioner, my lord. One.
petitioner, the learned counsel representing the opposite party number,
My lord, I am appearing for 1 to 4. 1,
opposite
2, 3, and 4.
opposite parties number 1, TO2, 1 to 4, commences his submission. Full stop. During the submission of the learned counsel representing the opposite parties number 1 to 4, it transpires that some documents had been relied upon by the defendant number 1 and 2, by the defendant number 1 and 2,
One.
defendant number relied upon by the defendant number 1 and 2, defendant number oblique opposite parties number 1 and 2 at the time of hearing of the temporary injunction before the trial court, that is civil judge, junior, junior division.
My lord, Civil Judge, Junior Division, Fourth
Division,
Court as
fourth
Srirampur.
court, fourth court, Srirampur,
Srirampur.
Hooghly.
Yes, sir.
But the details of the documents relied upon by the opposite parties, number 1 and 2, have not been reflected in the order of temporary injunction, being order number 35, dated 18/4/2023. Full stop. In such circumstance, the record of the title suit being number 70 of 2021, pending before the said civil judge, aforementioned civil judge, junior division, is called for. Full stop. At this stage, the learned senior counsel representing the petitioner submits that he intends to submit the special messenger cost for bringing the record. Full stop. Mr. Srivastava,
Your Lordship,
when
the records are now lying in the MITS appeal. So, Your Lordship will kindly direct that to be on forward. It is lying with the MITS appeal file.
he further submits that the record of the trial court
Your Lordship will direct the learned district judge, he will get collected from it.
he further submits that the record of the trial court being title suit number 70 of 2021, pending before the civil judge, junior division, fourth court, Srirampur, Hooghly, is presently
Before the learned addition,
in the custody of the civil judge,
no, additional
learned-
district judge, second court,
additional
Second
district
court, the
judge,
first court, sir.
second court,
additional district judge, second court.
second court.
In connection with
Srirampur.
Miss Appeal number 25 of 2021.
Additional district judge, second court, Srirampur, in connection with miscellaneous appeal number 25 of 2023. Full stop. In such circumstance, the direction upon the learned district judge or the additional district judge,
Whatever,
whom it will be better. The concerned court, the concerned court is directed to provide the record of the title suit 70 of 2021, pending before the civil judge, junior division, fourth court, Srirampur, Hooghly. The cost of this special messenger
by Friday,
by Friday. Full stop. He further submits that within this week, the cost of the special messenger shall be submitted. Full stop. Paragraph. Department is directed to do the needful at the earliest, so that the record is received at this end by by 19th of August, Wednesday, by 19th of August. Let the matter appear on 21st
Friday.
Of August.
My lord, 21st, I won't be in Calcutta, my lord.
24th,
My lord, 24th, absolutely
let
fine.
the matter appear on 24th of August. এটা ওই ডিপার্টমেন্টে না একটু বোল্ড করে দেবেন, বুঝেছেন? এটা আপলোড করে ডিপার্টমেন্টে পাঠিয়ে দেবেন।
My lord, 24th, my learned friend has, my learned advocate on record has some, if it could be on the 25th, my lord.
25th,
I'm extremely
25th.
grateful to my lord.
এগুলো সব থাকবে। Next.
For the first time, I am appearing in this matter before my lord.
Earlier,
Justice Parthopratim Roy was appearing.
thereafter, someone else was appearing.
No, a day before yesterday, my lord, adjournment was paid for on my ground. A day before yesterday, I am briefed. My lord,
এটা লাস্ট অর্ডারটা কোথায়? আজকে 12th অগস্ট। কত লাস্ট? হ্যাঁ, ঠিক আছে, ছিল না কেন? কেন? আমি তো সই করে পরশু, কালকে ছিল, কালকে, হ্যাঁ, ঠিক আছে।
On last August,
Yes.
there was a direction for filing supplementary affidavit disclosing the statement of accounts. There was a direction.
1 minute.
27th March order, my lord. 27th
uh,
March
Let
2026.
us first, this is the first time it is being heard. 37 lakhs something was,
38 lakhs.
38 lakhs due.
38 lakhs was directed to be paid.
No, it was observed by my lord that it was paid.
Principal amount has been paid.
Yes.
The interest amount is due.
Interest, my lord,
It is
is-
equal to 38 lakhs as of today.
So, Wide order dated 14th of August 2025. Mr. Roy, learned advocate, appearing on behalf of the petitioner in his usual fairness, submits
That was the
that the said
admission order.
Said order is an appealable one. He has
Yes,
an
yes.
instruction, submits that the petitioner is ready and willing to refund the amount of 38 lakhs to the opposite parties herein as directed by the impugned judgment and order. He further submits that the instant application has been filed praying for waiver of a portion of the interest amount. Petitioners are directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement due and file an affidavit of service by the next date.
Then, my lord, kindly see that was the order of Honorable Justice Hiranmoy Bhattacharya.
Yes,
Now, my lord, kindly sees my lord's order dated 27th March 2026.
yes, 27th March 2026.
Here, my lord,
To the
learned
petitioner
counsel,
submits that rupees 38 lakhs, that is the entire principal amount, has already been paid on 30th August 2025 as per the direction of the State Consumer Disputes Redressal Commission, West Bengal, wide order dated 12/6/2025. Learned counsel representing the opposite parties, the entire principal amount has been received by them. So as regards to 38 lakhs, there is no controversy,
Yes.
no dispute.
there is a controversy.
No. Hi.
Learned counsel representing the opposite party submits that the entire principal amount has been received by them.
Now, see, kindly see the supplementary affidavit. They have filed today.
As regards to the interest, now as regards to the interest, learned counsels representing the petitioners and the opposite parties submit that they would exchange among themselves the statement of accounts as regards to the interest which is to accrue till 31st March 2026 and apprise this court on 10th of April
Now,
2026.
kindly see the supplementary affidavit, my lord, they have filed today. Dee din, Joseph ke din.
Copy has been served.
Yes. Page 2. Paragraph 3.
Yes.
That after giving due credit and adjustment of a sum of rupees 38 lakhs remitted by the petitioners, judgment debtors and encashed on 30th August 2025, the outstanding balance amount payable by the petitioners, judgment debtors stands at 38 lakhs as on 31st March 2026. A true copy of the statement of accounts annexure. That the petitioners, judgment debtors are jointly and severally liable to pay the aforesaid outstanding amount of rupees 38 lakhs as on 31st March 2026.
As per
My lord,
calculation.
I do not understand the meaning of these two paragraphs. In one paragraph, he is saying that I have paid. In the next paragraph, he is saying it is due.
Very confusing. This is interest
You
component.
have confused.
Learned counsel, now you have raised the issue, raised the question. Let him apprise the court. Paragraph 4.
Yes. Kindly come to my calculation. Page number 5.
No,
Amount incidentally matched, but this is the interest component. Come to the page number 5. I am not disputing the principal amount that is received. As per the calculation, 38 lakhs, incidentally it has matched with the principal more or less. 38 lakhs 329 is outstanding towards the interest component. That is the computation as per direction of the State Commission.
No, this is his computation.
So let the matter be adjudicated by the National Commission because the appeal position
When
is
my
there.
lord has interfered, it will be heard by my lord.
No,
The jurisdiction.
jurisdiction issue
Yes.
is not
No,
there.
kindly
No.
see my lord's order. In that
No.
order, my lord has already interfered. Now let me show your lordship one thing.
Lordship interfere only for
No,
the matter
no,
can be
to
settled
that-
amicably.
That
Yeah.
principle,
Yeah.
to that amount only on
Could
that.
have taken that point before the National
No, why
Commission.
should I go?
Kindly see, they have calculated the interest at the rate of 12% per annum. Page 5.
As per direction.
No,
Yes, page 5, which portion?
top. Annual rate of interest 12%.
12%.
Now, my lord, kindly see the impugned order. Page 108. The second last page. Before back sheet. 108. The ordering portion. See the ordering portion, the reverse page.
Yes.
The second paragraph of ordering portion. The OPs are directed to refund rupees 38 lakhs only to the complainants along with interest at the rate of 10% per annum. From the date of each payment till the date of realization in the form of compensation within 60 days hereof. In default, the entire sum shall carry interest at the rate of rupees 12% per annum instead of 10% per annum till date of realization. This order has been challenged in this honorable court. Rightly or wrongly, that different issue. This order has been challenged. So, my lord, interest should be at the rate of 10%. They cannot calculate at the rate of 12%.
In default.
If I have not come to this honorable court or I have not gone to any other forum, my lord, if I have not paid the interest at the rate of 10%
Then
within
counsel-
60 days, then
then-
my lord, 12% can arise.
Then learned counsel, that issue arises, crops up. Whether this one is at all tenable or not.
Yes.
Number two,
If you raise that issue, the issue crops up whether this one is tenable or not before this forum.
the next point,
Next point.
51 lakhs was the Milord agreed amount to be paid by them. 51 lakhs. That is Milord observed in the input order also. They have paid 38 lakhs. When they have not paid the entire amount, Milord, first of all, they cannot claim Milord interest on the money that they have paid. Now see the payments that they have made. How they have made payments? 1 lakh, 1 lakh, 2 lakhs, 2.5 lakhs, 4 lakhs.
Yes, learned counsel. The OPs are directed to refund
That operative part.
operative.
Yes, I am also. The OPs are directed to pay 38 lakhs at the rate of 10% within 60 days. When the order was passed on 12 June 2025. 60 days means July, August, 12th August.
I'm not going into the rate of interest now.
Okay.
the OPs are directed to refund 38 lakhs.
Yes.
So you have calculated whatever it may be. Rate I am not discussing, whether it is 10% or 12%. OPs were directed to refund 38 lakhs. So you have calculated 12% on 38 lakhs or on 51 lakhs?
No, no,
38 lakhs.
38 lakhs.
30
As and when I have deposited, from that the interest has been charged.
4.4
May I kindly
lakhs,
come 1 second? I am just, one second.
56,000
Learned
every
counsel-
year.
learned counsel, it would be better. You are disputing his calculation. You place your calculation, how much it comes?
Your lordship direction was there. Despite of that, they have not filed their calculation.
Milord, kindly give.
No, then
Today I am appealing for the first time.
after
I
6
have not
months,
done.
This issue cannot be raised.
This
but-
issue has to be raised because
No, no,
today I am
no,
appealing
no,
for the
no,
first
no.
time.
It is upon your client.
Yes. Now, Milord, kindly
At the time
give
of
me an
hearing,
opportunity
at the time of
to
hearing, when hearing has commenced, one cannot hand over a brief from one to another. That is your client's decision. We are not at all concerned.
I cannot say this has been done, which has not been undone.
But but the issue is, there was direction.
There was direction, Milord.
That has
I
not
have
been complied.
asked my
That-
junior also.
That can be extended. That can be extended. But within how much time you can provide the
2 weeks.
your statement?
2 weeks.
No. Why 2 weeks? 2 weeks is much more than you deserve. Yes.
I deserve.
Calculation, it will take 2 weeks.
1 week.
1 week. And the copy has to be provided.
Definitely, Milord.
When the copy has been provided to you,
Copy has been
I have
given to
been-
me on Milord. Advance copy, Milord. 6th of
advance.
April, it was Milord
6th of
handed over.
April, I
6th
have
of
supplied, and now
6th
we
of
are
April.
August. They are taking time. Now we are in August.
Milord, this is Milord hard today.
No opportunity.
Called on
should
today.
be-
I have
it is
checked
not a
up.
fit
I
case.
have checked
because
up,
this
Milord.
is not
One date, Milord, it appeared. in
Learned
the
counsel-
list.
appellable order.
10th April, Milord. 10th April, Milord. The affidavit
counsel-
has been affirmed. Advance copy has been given to me.
do you want to resolve the dispute?
No,
or-
no, I want to resolve this. I want to resolve this. I want to resolve this.
When can you be able to provide the statement of accounts? Your statement of accounts?
কবের মধ্যে দিতে পারবে ইনস্ট্রাকশন নেওয়া যাবে না তোমার আগেই মার্চ মাসে
No, no,
তোমার উপর অর্ডার আছে
Time have passed by.
হ্যাঁ মার্চ মাসের অর্ডার
Tell me they are not interested.
ডোন্ট মেক কমেন্টস স্যার আই এম নট মেকিং এনি কমেন্ট
Learned counsels,
আই এম টকিং টু মাই জুনিয়র
learned counsels. We have to resolve the
দিস
issue.
রানিং কমেন্টস মাস্ট বি স্টপড বাই মাই লর্ড
Learned counsels.
2 সপ্তাহ দেবেন না জজ সাহেব বুধবারের ভেতরে তোমাকে এটা করে ফেলতে হবে এফিডেভিটটা করে ফেলতে হবে বৃহস্পতিবারের ভেতরে ওনাদেরকে কপি দিয়ে দিতে keep it on Friday, Milord. By that time, I shall I shall get my affidavit, Milord, ready with my statement of account.
21st, it is being kept. 21st of August.
Milord, they are paying, Milord, 1 week more, Milord, because they have to contact the client, Milord, since a long time has passed, and Milord, they have received 38 lakhs. It's not that they are without money.
Today,
have received the money.
Today is 12, 21, it is being fixed on 21. You provide them the copy on 19th.
Milord, my lord is sitting every day right now, Milord. Kindly keep it on 26th. Kindly keep it. It's my request, Milord, personal request. Kindly keep it on 26th. They need some time to talk to the client and, Milord, get the tabulation ready.
When will you provide the?
I shall provide, Milord, the day on which it is affirmed, Milord. I shall provide on to him
Should not be indefinite.
by 25th.
No. By 21st. By 21st.
By 21st, by Friday week. Very well.
Yes.
Friday 21st.
The matter will appear on
If it is, Milord, given to them, Milord, then
Which
let it
date?
be on 25th.
24, 25, no problem.
25th. The supplementary affidavit of statement of account on behalf of the opposite party number 1 and 2. You have filed today. You are filing
Yes,
today.
yes.
The supplementary affidavit on statement, did apology. Supplementary affidavit on statement of account has been provided today. Let it be kept to the record. Furnished today, provided, no? furnished today. Let it be kept to the record. Full stop. At this juncture, paragraph, at this juncture, the learned counsel representing measures Songhoti Construction and other, that is the petitioners, representing the petitioners, seeks an extension of time to file statement of account on behalf of the petitioners for a fortnight. Full stop. Paragraph. Consider the submission of the learned counsel representing the petitioners. Let the statement of account on behalf of the petitioners be provided to the learned counsel representing the opposite parties number 1 and 2 by 21st of August. 21st of August 2026. Full stop. Let the matter appear on 25th of August. 25th of August 2026.
21 ভেতরে অর্ডার হয়েছে কিন্তু 21 মধ্যে ওনাকে 21 ভেতরে ওনাকে কমপ্লিট করতে হবে। I'm grateful.
Lordship, in this matter, I am appearing on behalf of the petitioner. Lordship is seeking an accommodation for today because the learned counsel appearing in this matter has some family problem today, so he is unable to come to the court today. Kindly grant me an accommodation for this, Lordship.
First time আসছে।
Yes, your Lordship.
First day,
Yes,
first
sir.
day. Go through the order number, order dated 4th of September 2025.
Lordship,
Paragraph
actually,
number 2.
Lordship, actually, I don't have the brief. It is in lying with my counsel, sir. Kindly give me
Who is the
adjourn-
advocate on record?
Lordship, Mr. Anirban Roy is an advocate on record.
Where is he?
Lordship, due to some family inconvenience, he is unable to come to the court today. Kindly grant me an adjournment for this day, sir. I am seeking,
For how many days?
Lordship, for today only. Kindly keeps it tomorrow.
Tomorrow.
Yes, your Lordship.
ওনার নামটা নেবেন। Learned advocate representing the petitioners seeks an accommodation for this day on the ground of personal inconvenience of the advocate on record. Full stop. Let the matter appear tomorrow. Learned counsel, there is an order dated 4th of September 2025. Take note of that. There is an order dated 4th of September 2025, wherein it was directed that the petitioners are directed to serve a copy of this application upon the opposite party by registered speed post with acknowledgement due. Whether it has been complied or not,
Lordship.
let the matter appear tomorrow. নামটা নিয়ে নেবেন।
For my lord, I am appearing on behalf of the respondent. In this case, my lord, appellant has filed one substitution application And previously matter was dismissed for default, and one application for restoration is still pending, my lord. That was dismissed for default. Date is, my lord, 17 June
Sole
2019.
appellant, sole appellant.
No, one of the respondent.
No, who has expired?
One of the respondent.
Respondents. So one of your client,
Yes. Joydev Ghosh.
but
One can
no, again order the last order. Where is the learned counsel?
previously it was dismissed for default. Till now not been restored. On 17th, my lord, kindly see order dated 17 June 2019.
None is representing the appellant's petitioners. None is representing the appellant's petitioners. In such circumstance, the matter cannot be proceeded. Let the matter appear on 17th. Let the matter appear on 17th of August.
17th. My lord, instead of 17th, 18th.
18th. Let the matter appear on 18th of August.
হ্যাঁ 17th ওখানে আছে। না দুটো পেন্ডিং, এই ক্যান 7 of 26 আর একটা আছে ডিসমিস ফর ডিফল্ট হয়েছিল, এটা হচ্ছে 2019।
Item number 5 minutes. It's on the paper page, you know? Page of section.
Yes, the 5 has to.
Huh?
Process can you see the order dated 20th March 2026. When my learned friend failed to appear, but we have regularized the CAN applications. 20th March.
20th March. So,
Lordship's order.
Is there any application pending?
Yes.
Which application is
Application CAN number 5 is pending.
pending? CAN 5 of 23.
23.
Apart from CAN 5 of 2023, none of the applications are pending. The department is directed to the needful in this regard.
All application has been regularized by your lordships on that date. My learned friend failed to appear on that date. We assisted your lordship. Only CAN 5 is pending. আপনাদেরই তো আমরা CAN 5.
And 3.
এক মিনিট, CAN 4, CAN 5 এখানে আমি লিখেছি। এইটা কি আছে দেখুন, দেখিনি। CAN 5. Oh, an application for further injunction. Fresh injunction.
That has been, your lordship also dispose of the main injunction application and till disposal of that.
No. CAN 5 has not been.
Your lordship kindly look into your lordship earlier orders.
Wide order dated?
My lord, this is your lordship paper book, my lord.
That has been disposed of by order dated.
Possibly, my lord, if I am not wrong, my lord.
Wide order dated?
My lord, 25th of March 2022.
Lord Counsel, when the hearing is being taken up, There's no use of
No,
taking up the injunction application. We can take up the
main
hearing
appeal,
itself.
your lordship.
Main
can-
appeal.
Only fixed any day.
No, no, no. Mr. Datta will start today, provided he starts today.
This is very short compass, my lord.
Always,
Only one
no.
day time required.
No.
Yes, yes.
uh,
Yes, let
Let
my
me
learned friend
start,
start.
my
chale-
lord. This is judgment against my lord.
no, we'll have to assure in the meantime whether 5 of 23 has been disposed of or not.
Right, my lord. I am, my lord, I am
Learned
assisting.
counsel, it will be better.
I am assisting your
Let
lordship.
us, let us, huh?
I am assisting your lordship.
বলুন কবেকার অর্ডারে হয়েছে দেখুন না
দেখে বলে দিচ্ছি দাদা।
আগের দিন আমরা দেখেছি হয়নি জজসাহেবও দেখেছেন হয়নি তুই যা ওখানে যা হুম হ্যাঁ My junior is taking leave. I'm appearing only. That's আপনারা ধরবে
Mr. Datta, during the course of this day, let the learned advocate on record go through the record and apprise tomorrow. Let us start the hearing.
Let's start.
So far my knowledge goes, it has not been
16,
disposed
16,
of.
12.
The date is 16th of December 2022. Junction was disposed of regarding the response for not getting
16th of December 2022. Hmm.
And 16th of December. No, it can't be, because in the year 2023, you served this copy.
22.
Oh, but 23, you have
Yes.
served copy of section 5, application number 5.
No,
No, jhogla na.
learned counsel is correct because his application is of 2023.
the order. I submitted to the lordship, the order.
16 December 2022.
না 2022 can 2022 হতে পারে তাহলে ভুল করে সার্ভিস করেছে
Having considered the submission of both sides, the injunction application being can 2 of 2014 be disposed of with the direction that pending decision of the appeal, no third party interest be created. So not to alienate, no third party
that-
interest be created.
That means
that is can 2, it is can 5.
can 5 extension.
No third party interest be created touching the subject property in any manner whatsoever.
Can
So-
5 is become infractious,
Yes, 1 minute. Can 5 is
possible for extension.
no,
For further appropriate order.
an application for fresh injunction with
Yes.
interim order.
Lordship has already taken note of that on the
Let this one
previous
be not
office.
pressed. Not pressed.
Here also can you
Nil. From the, so it is not
no,
being
my
pressed.
lord,
Can-
my lord, I can remember that in spite of order of
On the
injunction,
previous
they are
office,
trying
Lordship's
to,
gone through it.
they are attempted to make construction. That's why we file application.
But
When the main appeal is
when the
being
main
taken up,
appeal is being taken up, it will be disposed of.
and your lordship, not to my lord, not from the, not pressed, my lord, your lordship kindly disposed of as the appeal is being taken up. As the appeal is, main appeal is, your lordship is being heard, and
The arrow goes towards
no,
this end.
this application has become infractious.
No, not in fact. It is mentioned that an application for fresh injunction.
No, my lord, fresh injunction when the respondent was making construction.
So what will you do with this one?
My lord, I am putting endorsement that when the appeal is being heard, I am not placing this application.
The learned senior counsel on behalf of the appellant or appellants?
Appellant.
Appellant?
Appellant, my lord.
No appellants. Two
Appellant.
appellants submits that the appellants do not intend to proceed with the application being CAN 5 of 2023 as the appeal itself is being taken up for hearing. Learned advocate on record, learned
Yes,
counsel,
my lord, record will.
during the course of this day, the learned advocate on record representing the appellants is directed to
Put endorsement on
put an
the.
endorsement in this regard during the course of this day. Let us take up the appeal.
Lord, you also kindly.
So no application is pending. So
Lord,
no
there are two
application.
paper books I have filed. And one
No
paper book, my
applications are
lord,
pending.
in respect of my true judgment of the.
We have dismissed for the not pressed. Dismiss being not pressed. Dismiss being not pressed. Acha, part 1 contains the judgment.
Two court judgment, my lord.
Judgment
Along
of
with my
the
lord, the order passed by the honorable court.
civil judge senior division and the first appellate court.
First appellate court.
Memo of appeal.
This is judgment against affirmation, my lord.
And 33 to 47 page.
My lord,
Admission at the time of admission, the order passed.
my lord, page, yes, my lord. There are two, my lord, my client is fortunate enough that she was not represented, but the honorable division bench, after considering the going through the records, and my lord, the appeal was admitted by the honorable division bench.
Page, which page?
Page, my lord, 38. Two substantial questions have been framed. My lord,
Substantial questions of law.
My lord, a further substantial question is required to be framed. After hearing your lordship, if so desires, that two substantial questions are required to be framed.
Dismiss being not pressed.
My lord,
Now, learned counsel, the facts of the case.
facts, my lord, this is a suit for eviction and recovery of first possession. We are the plaintiffs. Page 38, দেখো, first party.
Whether the learned courts below have erred in law in holding that an unregistered deed of gift
It is valid
as per provisions of section 25
of the Indian Contract Act, even though the said deed was unregistered.
unregistered. And the
Next,
second,
whether both the courts below clearly erred in law in arriving at a finding that since the unregistered deed of gift was never challenged, Exhibit B would be a title. By reasons of Exhibit B, the defendant number 1 becomes the owner of the property in question.
so the fulcrum is that unregistered deed of agreement.
Unregistered deed of agreement.
Deed of
That is a pure
unregistered
question.
deed of gift.
Deed of gift.
Deed of gift.
Whether it is a my lord, it confers any title or not.
Yes.
And my lord, there, my lord, firstly, my lord, I am my lord addressing their case.
Who is the landlord?
I am the landlord.
You are the
I am
landlord.
the owner. They are the encroachers. Unauthorized trespassers.
Trespassers.
My lord, you will also kindly look into the first trial court judgment.
Trial court judgment. 1 minute.
And I am reading, my lord, also kindly look into. Page 2 starts. And when I part 2, in part 2, you will also find that copy of the plain, copy of the written statement, and the evidences.
Thanks for providing that also.
That I have tried, my lord. And exhibited documents.
Mr. Datta, have you personally gone through the plaint and the written
Yes,
statement all?
Yes.
Because
That-
sometimes the
That
it differs
That-
from the original one.
Yes.
Sometimes. Yes, let us take the judgment of the.
From my document, I have typed it. And there may be some typographical mistake that
Let us take up the judgment of the trial court.
the trial court judgment page 2. The
Hmm.
plain case is that the shoot property as mentioned in the schedule to the plain belong to Ishtopada Datto alias Fonibhushan Bholanath Datto and Umanath Datto in equal share. And their names had been recorded in CSROR. It has stated that there was an amicable partition and thereby the Umanath Datto exclusively got the shoot property and thereafter he raised Pakka construction. The heirs of Bholanath Datto and Ishtopada are the co-defendants. In the suit, they have no title, they have no right title interest in the shoot property. The plaintiff are the children of Umanath Datto. It is stated that Shobarani Datto was the Bhagini of Umanath Datto. Shobarani Datto was issueless and on death of her husband, she took shelter in the house of Umanath. Shobarani Datto thus had no title or interest in the shoot property, but her name was recorded in RSROR and in ownership column RSROR and in possession column, the name of Umapada Datto was recorded without any basis and erroneously. It is stated that Shobarani Datto, without any right title interest, executed a registered document in favor of defendant number 1, who was the sister son of Shobarani in respect of a shoot property along with the other property. It is stated that defendant number 1, by taking such advantage, is trying to dispossess the plaintiff from the shoot property. It is stated that the said deed and recording ROR has cast a cloud over the shoot property. The plaintiff thus pray for decree of declaration, injunction, and recovery of possession. The defendant number 1 is contesting the suit by filing written statement. It is stated that there is no cause of action from the suit for the suit, and the suit is not maintainable. It is stated further that under section 34 of the Specific Relief Act, specific case the defendant is that the suit is plot number 1 decimal. This is very meager area of land. And the Fonibhushan, Bholanath and Umanath in the year 1938 by 1338, not 1938, 1338 PS, by an unregistered deed of transfer, by an unregistered deed, transferred the said land to Subhashini Rasi. This is the gift deed, unregistered gift deed. It is stated that Subhashini Rasi, thereafter with the help of brothers, constructed a house and started to reside there and with her husband. Subhashini Rasi died leaving behind her 2 daughters. The mother of the defendant number 1 was one of
As regards to genealogy, which has been provided, described herein.
I will make an I will hand up.
Provided.
I will make an reply.
Are you denying the genealogy? Is there any?
It is their case.
It is our case.
So let a genealogy be
Yes.
provided.
Uh,
During the course of this day?
no, not tomorrow actually.
Tomorrow.
Thereafter, another court I will go.
And a copy should be given to me so that I can verify.
Yes, yes, Mr. Dotto.
Another daughter of Subhashini, namely Shobarani, Subhandini, had been residing with her mother. After death of Subhashini and Subhandini alias Shobarani had been residing with the shoot property. In the shoot property, Shobarani was issueless and she became widow in her middle age. Shobarani on 21st of March 1993 executed registered in favor of defendant number 1. It is stated, I am pausing for a moment, but this deed of gift registered by the person who claims to be the owner by an unregistered deed. That's why.
So according to you, she did not have the right to give, to transfer.
And this transfer is void ab initio. When there is a void and nullity and in the eye of law, the Supreme Court held that there cannot be any challenge even ever. We cannot pray for declaration that deed of void and cancellation. When the deed is void ab initio, that is settled principles. We have brought the judgment of the Honorable Supreme Court. Now you will also kindly look into. In favor of defendant number 1, it is stated that the mother of the defendant number 1 died in his childhood, and the defendant had been residing with Shobalani under the care of grandparents. It is denied that there was any amicable partition in between Bholanath and others. It is also denied that Umanath got the property exclusively. It is stated that recording of R.S. Arwar by the name of Shobalani has gone out to correct the recording. It is wrong by the name of Umanath in column number 23. It is stated that on an application which says wrong recording, the name of Umanath has been corrected. It is submitted that lastly, the defendant is possessing the suit property and is paying rent to the government regularly, and the defendant thus prays for dismissal of the suit with cost. Thereafter, issue framed. These are the issues framed. Issues, my lord, whether the suit is maintainable in the present form and in law. Have the plaintiff any cause of action? Is the suit barred under section 34 of the Specific Act? Is the suit barred by principles of estoppel, waiver, and acquiescence? Are the plaintiffs entitled to relief as paid for? Then what relief and other relief? Then additionally, issue you will also kindly look into, have the plaintiff any rightful interest in the suit property? Now you will also kindly.
This is the prime issue now.
Yes.
The additional issue.
Additional issue. Now you will also kindly consider admitted facts that three brothers were the owners of the property.
ওই কি জানো ইষ্টপদ এলিয়াস ফণীভূষণ, ভোলানাথ দত্ত and উমানাথ দত্ত.
Yes, the three brothers.
Three brothers.
My case that upon oral settlement, oral amicable arrangement and oral partition, we are given this 1 decimal plan. My clients got this 1 decimal plan, and thus we are the owners from that and in the dwelling house in the property. We are in possession in respect of some portion. They are in respect of a portion where they are doing their business, giving shelter. They have taken shelter to live, but they are now carrying on business. That's why we filed application for injunction, just so that they may not be. They have changed this property, and they may not be permitted to make any further constructions. That's why we have taken out the application of Can 5. Now you will also kindly consider the decisions with reasons. Page 5 you will also find. Admittedly, the Phonibhushan alias.
Doctor, you didn't have discussion in the chamber?
Oh, sorry, my lord.
Yes.
He is very competent to. That's
That everybody knows.
No, my lord. Admitted fact that Phonibhushan alias Ishtopodo, Bholanath, and Umanath were the owners of the shoot plot, and their names were recorded in CSRY. The shoot plot number 6269 of land of 1 cent, consisting of pakka structure. It is the case of the plaintiff in between the said three owners. There was an amicable partition, and the shoot property was exclusively allotted in favor of Umanath. Thereafter, you will also kindly mark Umanath. We are claiming from Umanath.
Shoot property was exclusively allotted in favor of Umanath.
And thereafter made construction.
An amicable partition.
Thereafter, he made construction in the shoot property. The case of the plaintiff is that they are the children of Umanath Dotto. It is stated that Umanath Dotto had one Bhagina, namely Shobarani Dotto, and he was issueless, and after death of her husband, she took shelter in the house of Umanath Dotto. Shobarani had no title in the shoot property, but in her name, but her name was recorded in R.S. Arwar, and the name of Umanath was recorded in possession column thereof. According to the plaintiff, the said recording is wrong, and taking such advantage, Shobarani executed a deed of gift in favor of her sister's son, who is the defendant number 1. It is stated that Shobarani, without any right or right or authority executed the registered deed of gift and it does not bear any title. And my lord, you'll also kindly uh, from the decree and from the plaint, you'll also find there are other pro forma defendants. What the my lord, admittedly were our co-sharers. They have been made as pro forma defendants to avoid any dispute for further for defect of parties.
In
Whether-
future,
Whether amicable settlement of amicable partition is acceptable or whether I am entitled to get a decree for eviction, that is the subject matter. And my lord, this is the also position of law that any one of the co-sharer can file for suit for eviction. That is the settled principle. You also decided on these issues. Many issues I am also aware about the Supreme Court judgment also. I shall place before Calcutta High Court judgment, Supreme Court judgment. I shall brought Your Lordship. Next, Your Lordship. On the other hand, the claim
there's
of
a
the
judgment of Justice Bhaskar Bhattacharjee on this issue,
Justice Bhaskar 1997 Supreme Court also.
old one.
Yes.
Yes. On the
On the
other,
other hand, the claim of the defendant number one is that recorded owners since CSRO are executed an unregistered. Well, this is we will also kind of marked it. Unregistered gift. This is section 123 of the Transfer Property Act prohibits such transfers. Under the Registration Act, any document immovable property is required to be registered. Section 49. These are the two provisions, 123 and section 49 of the Registration Act. 123 of 1882 and 49 of 1908. Since then, Subhashini had been residing in the shoot property along with her husband and two daughters. After raising construction thereof,
Registration Act
on
আছে?
death of Subhashini, her two daughters had been residing in the
Indian Registration Act. Transfer Property Act আছে, Indian Registration Act. Yes.
We have a you'll also kindly.
No, let it be placed
123.
123 and 49.
Section 49 of the Registration Act.
First, 123 of the Transfer Property Act.
And I'm placing 123. No. I am reading. Transfer how effected for the purpose of making gift of immovable property. The transfer must effected by registered instrument
Yes.
signed by on behalf of the donor and attested by at least two witnesses. For the purpose of making gift of immovable property, the transfer may be effected either by registered instrument as signed by the opposite and delivery of possession. Such delivery may be made in the same by way of goods sold may be delivered. That is specific. And one of section 49 of the Registration Act, you will also find
A gift deed has
Must
to
be
be registered, having attesting witness
two attesting witnesses
and
and
delivery of
possession.
possession must.
Yeah.
These are the ingredients.
Giving and accepting.
And, acceptance of the
Acceptance and
donee is the also vital.
And this is also, now you will also kindly look into section 49 of the Registration Act. Effect of non-registration of documents required to be registered.
Yes.
No document registered by section 17 or any provisions Transfer Property Act to be registered. Effect of an immovable property comprised therein confer any power to adopt or receive any evidence in transaction affecting such property or confirming such affair. Provide that an unregistered document affecting money, this is for the collateral purpose that can be used. For the collateral purpose. Well, here, admittedly, the document is unregistered. Now, you also kindly, I am going to the.
Provided that an unregistered document affecting immovable property and required by this Act or the Transfer Property Act 1882 to be registered may be received as evidence of a contract in a suit for
Specific
specific
performance.
performance.
Let's not here, it is not specific, they have not, there is no counterclaim. There is no, my lord, separate suit,
This is the first, and the second is or as evidence of any collateral
only in
transaction,
respect of specific performance.
or as evidence of any collateral transaction not required to be effected by registered instrument.
Yes. And your lordship in the division bench already decided that oral agreement, unregistered agreement, I lost that matter.
Hmm.
Now your lordship kindly go back to the, my lord, page 5,
Page 6.
page 6. Second paragraph. On the other hand, the claim of the defendant number 1 is that the said recorded owners in CS Arwar executed an unregistered deed in favor of their sister Subhashini Dashi in the year 1338 BS. Since then, Subhashini had been residing in the shoot property along with her husband and 2 daughters after raising construction thereof. On death of Subhashini, her 2 daughters had been residing in the shoot property. The mother of the defendant number 1 was one of the said 2 daughters. Shobharani Datto was another daughter of Subhashini Dashi, who executed deed of gift in favor of defendant number 1 on 21st of March 1993. And since then, the defendant is residing in the shoot property. It is stated that the original owner filed proceedings under section 44 of the Estate of Acquisition Act. But after hearing the name of Shobharani correctly recorded in RS Arwar, it is denied that Shobharani was permitted to take shelter in the house of Umana. From the side of the plaintiff number 1 laid evidence as PW1. During examination, CS Arwar have been marked exhibit 1, 2, 3, 3A, such and such. On the other hand, from the side of the defendant number 1, the defendant himself as DW1 and one Sudhir Das DW2 laid evidence from the side of the defendant unregistered deed of gift in the year 1338 BS has been marked exhibit A. My lordship also marked this exhibit A, marking of a document and its dispenses proof that these two things are very different. That's its legality and validity. Even marking, we can raise this question.
That is
the
substantial question of law.
That is a
frame.
substantial question of law. Yeah, another gift deed in original has been marked exhibit B. This is the, my lord, subsequent registered deed, which is void ab initio.
As the donor did not have
confer any title.
Did not have the right
Did
title.
not confer any title, had no manner of right, title, or interest.
It is your contention.
So any document created or executed
Banking upon unregistered deed of gift.
that is void ab initio and nullity in the eye of law. Exhibit B, exhibit C is the searching slip, RS Arwar, exhibit D is the LR Arwar, exhibit E series, and at the order sheet under section 44 Estate Acquisition Act, exhibit F2, F3 are the rent receipts, such and such cousin receipt. You also kindly take note of it that documents does not create title or extinguish title. It is mere a document of possession.
Record of rights do not create title.
Created or extinguished title. On careful consideration of the said pleadings of the parties and oral documentary evidence, I find the plaintiffs have not been able to establish that there was any amicable partition in between the recorded owners of CS Arwar. PW1 in his cross-examination has admitted that I have no paper to document to show that any partition was ever took place in between the co-sharers. Exhibit E, I am calling for a moment, you also kindly consider that other co-sharers have been made parties in this proceeding, the pro forma defendant. We are
because their presence is required to know about the decision in the.
We are paying for recovery of possession and eviction. Main prayer declaration, we are the owner of the property, and consequential prayer, the eviction and recovery of possession. And if your lordship finds that the plaintiff and the profound defendants are the joint owners, then eviction will not go. They are not coming to contest. They are not, if the recovery position be made, then the other co-sharer will get the property. That's why your lordship judgment, you also already referred, Justice Honorable Justice Bhaskar Bhattacharya's judgment. Any one of the co-sharer can file a suit for eviction. PW1 in its cross-examination has admitted I have no paper to document to show that any partition was ever took place in between co-sharers. Exhibit E series goes to show that Bholana Dotto and Phanibhushan Dotto and alias Ishtopada Dotto raised objection under section 44 of the State Acquisition Act. The said application and order sheet speaks that Umanath Dotto, Umanath directly was not a party to the proceedings. But I am claiming from Umanath. I am not a party to the State Acquisition Act proceedings.
Your predecessor was,
Not my other co-sharers,
other co-sharers.
who upon amicable arrangement, my name was recorded, but I have not been made party.
Umanath was not party to the proceedings.
So even this order is not binding on us. Proceedings to record his name in RSROR and to delete the name of Subandini from the ownership column. Therefore, I hold
Shubhanandini.
Shubhanandini from the ownership column. Therefore, I hold that plaintiff did never challenge the recordings of the RSROR. From Exhibit A, it appears to me that Bholanath, Ishtopada and Umanath executed gift deed in favor of Subhashini Dashi. My Lord, Your Lordship, this gift deed is nothing, mere paper. Until it is a registered gift deed, no value in the eye of law. The deed is unregistered one. The value of the property has not been mentioned there. The deed is of the year 1338 BS. The land is 1 decimal. Therefore, the court is not in a position to take view whether the instrument was required to be registered or not. The deed, well, this is totally perverse. The deed Exhibit A has not been challenged by the plaintiff. The deed is over 75 years. This cannot be a deed. This is mere a writing. Unregistered instrument, this is mere a writing. This is the total judgment of the trial court.
The deed has not been challenged by the plaintiffs. That's why.
Both the trial court and
more than 30 years old document. The deed is over 75 years old. On the banking upon this, the judgment
everything has been done.
Thus, I hold that the Exhibit A bears title for the defendant number 1 on strength of Exhibit B. Yes.
Here there is no discussion that I have no title. Here there are 3 co-owners, the co-sharers, admittedly, and out of within 3 co-sharers that amicable partition, my case I got from my other brothers pro forma defendants. And I have filed the suit for eviction, declaration that I am the owner in respect of the entire 1 decimal, along with there are other properties also. My other brothers got the other properties amicably. Recent Supreme Court judgment also held that if a person, they orally partition, and the persons are in settled position of those, and there are other registered documents to that effect, and section 14
given effect to
that partition has accepted. It is presumed that partition has taken place. This 2025 volume 5 SCC I have brought it. But when I shall place the judgment, I shall place the judgment. My lordship, this is then my lord kindly consider the appeal court judgment. This is page
2025 volume 5 SCC page.
My lord, page 198.
198.
Paragraph 12. Paragraph 12 and 13.
Yes.
Very recent judgment.
Volume 5, na?
Volume 5. Now you will also kindly appeal court judgment. This is totally replica. Case 13 starts.
Yes.
Second paragraph. Plaintiff's appellants have filed title suit number 55 of 2004 before the trial learned court below for declaration of title and recovery of first possession. The case of the plaintiff appellant in nutshell is that the suit property originally belonged to three brothers, namely Phonibhushan Dotto, alias Ishtopadra Dotto, Bholanath Dotto, and Umanath Dotto, having equal shares, and then names have been duly recorded in CSRY. There was an amicable partition amongst the three brothers. By and between, Umanath got the suit property exclusively, and other two brothers got other properties, which have submitted to your lordship. Other properties in lieu of the suit property. Umapadra, after becoming the exclusive owner of the shoot property, started to possess the same after raising Pakka construction over the shoot land. And after the demise of the said Umapadra Dotto, the present plaintiff's appellants, being the sons and daughters, inherited the shoot property and started to possess the same. In the case of the plaintiff's appellant that Sovereign Dotto was Bhagini of the deceased Umanath Dotto, Sovarani Dotto was issueless, and after the death of husband side took shelter at the house of Umanath Dotto. Sovarani Dotto had got no right title over the shoot property. She used to decide at the house of correctly used to decide.
Mr. Dotto, there was nobody in the name of Uma Podo. Only Umanath.
Umanath. There may be some fabricable mistake, my lord. From the original judgment, your lordship, so kindly compare it. Your lordship will get the same.
So after the demise of the said Umanath, the present plaintiffs, appellants, being the sons and daughters, inherited the suit property and started to possess the same.
Right.
Yes.
My lord, your lordship kindly considered Sovarani Dotto had got no title to the shoot property, and she used to reside at the house of Umanath Dotto and got her name wrongly recorded in 13th Kalam of arrest record as the owner of the shoot land, and the name of Umanath has been wrongly recorded name at Amuti Dakuldar.
Onumoti
Dakuldar. Permissive possession. They are banking on these documents and succeeded to record some way, but on the basis of that, the court declared their title.
It is mentioned that Shobarani Dotto had no right title over the suit property. She used to reside at the house of Umanath Dotto and got her name wrongly recorded in the 13th column of the arrest record as the owner of the suit land. And the name of Umanath has been wrongly recorded as Onumoti.
Onumoti Dakuldar. CS record, our name was there. In arrest record, changed. Then, the said Sobarani, having no title and interest over the shoot property, executed the registered document in favor of the defendant number 1. This is your lordship marked it. Sobarani had no title. On the basis of record, she cannot claim that I am the owner of the property. Defendant number in respect of shoot properties and others. The said respondent, the defendant number 1, did not acquire any right title interest over the shoot property, but on the basis of the said registered document and erroneous settlement records, the respondent defendant number 1 started to possess the shoot property. Hence, the plaintiff appellants have filed the case before court below for declaration of their title and recovery of possession. The principal defendant number 1, Devnath De, contested the suit court below, possibly by filing his written statement denying all material allegations made by the plaintiff appellant. The specific case of the defendant respondent number 1 is that the shoot land area consisting of 1 decimal of land has been transferred by the said Phonibhushan Dotto Bholanath Dotto and Umanath Dotto jointly in favor of the Subhashini Dashi. My lord, Subhashini Dashi, by executing a registered deed, this is totally wrong. This is unregistered. Registered in India 1338 BA. Thereafter they said Subhashini, and my lord, the gift deed also not by Umanath. Therein with the husband said Subhashini Dashi died leaving behind her two daughters.
Who had gifted that unregistered gift deed? Not
Your Lordship,
Umanath.
Consider the document we have enclosed to your lordship find.
Learned senior counsels, have you gone through the record? All the documents are there. Exhibits.
Exhibits.
During the course of this day, kindly go through the record.
Well, I have mentioned. Exhibit A, my lord, you will also find part 2.
Unregistered gift deed executed by Bholanath Dotto
Bholanath Dotto
and two brothers
in favor of
Subhashini Dashi on 22nd Falgun 1338.
This is unregistered. Registered gift deed by Subharani Dotto in favor of Devnath Kumar De. This is wrongly typed. Being deed number such and such. Executed and this is with objection. This
In registered gift deed executed by Shobharani Dotto in favor of
Devnath De. DEOY. The sister son of
Devnath De.
Half sister son.
Achha.
These documents marked with objections.
Both marked with objection.
And my lord, page 27, you will also find exhibit 1. Shubhanandini Dotto, R.S. Arwar.
C.S. Arwar and R.S. Arwar.
R.S. Arwar.
Marked exhibit 1, 2, 3, 3A, 4 and 4A.
Yes. These are the documents. Now you'll also kindly, my lord, I am coming back to my lord, the appeal court judgment. Subharani Dotto started to possess the shoot property by residing therein. It is further case of the defendant that Subharani Dotto was issueless and became widow in her middle age. As her mother, defendant number 1, respondent number 1 died on the childhood of defendant number 1. The respondent number 1 is being brought up by the said Subharani Dotto on 21st of March 1993, and Subharani Dotto transferred the shoot property in favor of defendant number 1, respondent number 1. By executing a registered deed of gift, this is the, my lord, their title, Alice title. The defendant has denied all the plaintiff's claim by amicable partition amongst Bholanath and his two brothers, and this property got by Umanath exclusively. He stated that Umanath admittedly got the share. Their claim not exclusively.
Not exclusively.
If Umanath has a share, not exclusively, then Umanath also has the right to file suit for eviction and recovery also. He stated that the name of Subharani has been correctly recorded in R.S. Arwar and the name of Umanath has been wrongly recorded in 23rd column of R.S. record. Defendant is possessing the property exclusively by paying rent to the government. Proceedings initiated by Bholanath Dotto and other under section 44(1) of the West Bengal State Aggression Act, claiming erroneous entry in R.S. record in the name of, my lord, regarding R.S. record, section 44(1) will not come into picture. There is R.S. record. That is section 50 of the West Bengal Land Reforms Act. CS, if there is a correction in the CS record, then question of estate acquisition will come into picture. And the state proceedings has been finally decided in favor of Subharani Dotto. Hence, the defendant has paid for dismissal of the suit. This is their entire defense of the defendants. Next, the observation of the learned judge, learned appeal court. Upon pleadings, respective parties of the suit issues were framed and learned court below, and after taking evidences of respective parties, and after hearing the respective parties. My lord, here, my lord, I am also raising this question. When the first appellate court will decide, he has to decide all issues. Separately, he has to deal with under section 96 of the Code of Civil Procedure. The appeal court did not consider the issues of the trial court in a manner decided with in a shortcut method adopted. Supreme Court held, and section 96 also speaks about the order regarding decision order 41, rule 31 you also will find, and section 96 of the Code of Civil Procedure. What is the duty of the first appellate court? Like a trial court.
All
But
the issues have not been dealt with by the first
Not
appellate
at
court.
all. That's why this judgment is also bad. That I shall argue on I am arguing on this point. The duty of the first appellate court, first appellate court did not discharge his duties in deciding the first appeal. He has to decide all issues separately according to his own decision. He cannot put the decisions of the trial court. Independent decision, independent observation is required in deciding. This is the question of law. Independent decision regarding issues. Trial court decided issues from one angle. Appeal court may decide, may support the trial court judgment, but of his own, not depending on the trial court's observations. Now, on the point of consideration of the instant appeal is that as to whether the impugned judgment and decree passed by the court below was justified or not. Well, this is totally wrong. And the court has to decide the issues. What are the trial court issues? I am deciding the trial court issues. These are the issues. Now, decisions as a whole, court decided. Now, you also kindly consider. It is admitted position the case that the shoot property originally, this is decision with reasons, page 17. This admitted position of the case, the shoot property originally belonged to the three brothers, namely Phonibhushan Dotto, Bholanath Dotto, Umanath Dotto, and their names have been duly recorded in arrest record. SCS record. As per case of the plaintiff appellants, where was amicable partition amongst the said three brothers. In the said partition, Umanath Dotto got the entire shoot property and became the exclusive owner of the shoot property, and used to possess the same after making pakka constructions therein. On the demise of the said Umanath, the plaintiff have inherited the shoot property and became the owner. Whereas on the other hand, as per the case of the defendant, this is very cryptic. My entire case has not been properly dealt with. Very cryptic. I have raised this question that unregistered deed of gift is not valid in the eye of law, and no title can be conferred on the basis of that registered deed. When their transferor had no title, any transfer becomes nullity in the eye of law. Now, we'll also kindly on going to the evidences adduced from the side of the plaintiff. It appears that there is no evidence on record in support of the claim of the plaintiff appellant, and there was amicable partition among the said brothers, and Umanath Dotto had got the shoot property by virtue of the said amicable partition. He used to possess the same by making pakka construction therein. Admittedly, it appears the name of Sobarani has duly been recorded in arrest record. It also appears from the Exhibit 1. The name of Sobarani has been recorded in arrest record. As per the case of the plaintiff appellants, the arrest record has been erroneously recorded in the name of Sobarani. From Exhibit E series, it appears that Bholanath Dotto, Phonibhushan Dotto had initiated. Here also you find that my predecessor Umanath has not initiated this proceedings. West Bengal State Acquisition Act, case being number 2 of 1957. claiming such wrong entry in arrest record in the name of Sobarani, Sobarani and Sobanandini, it appears that Umanath Dotto, this TT was not party in the proceedings. Here, my lord, you'll see my argument, you'll will find that Umanath was not a party to the proceedings. Party to the proceedings, it appears that objection was made by the said Bholanath and another was rejected by the revenue officer. My lord, I am putting this question myself. If I am not a party to any proceeding, whether that order is not binding on. Apart from this, record does not confer any title or extinguish title.
Yes.
At the time of argument, a lawyer for the appellants argued that there is no foundation of entry made in the arrest record in the name of Sobarani. The unregistered document Exhibit A has no value and the defendant cannot claim by virtue of the said document that Subhashini Dasi had acquired title over the shoot property. The lawyer for the appellant refers to the decision 88 CWN 162, wherein the Honorable Court has been pleased to hold the entry in arrest record to be correct unless contrary is proved. But when matter is investigated by the civil court and parties adduce their evidences on the point of any controversy, the entry loses its weight when the evidences disclosed this is the matter when the matter before the civil court, and civil court ought to have decided that record does not create title or extinguish title. By producing record, they cannot claim that title has been. Their document itself is a bad. They are claiming title on the basis of a registered deed from their transferor who had no title. There are the judgment of the Honorable High Court, the division bench of High Court and the other judgment I shall place before Lordship. This next, on the other hand, the learned lawyer for the respondent argued, this is their arguments. There is no any rebuttal evidences on record from the side of the appellant in respect of RS server. They are only their case on the basis of the RS server. And further argued that the party relying on the presumption of correctness of the settlement record not prove the foundation on the basis thereof. Any entry RR is presumed to be correct unless it proved by incorrect to be incorrect by evidence in support of the connection of the learned lawyer for the respondent refers to decisions AI 1965 Calcutta, wherein the Honorable Court has been pleaded whole. The RSR is presumed to be correct until it is proved by any certain subject. But here, the court ought to have considered that they had record on the basis of the document that registered deed of gift. And they got the registered, I am repeating, your lordship kindly excuse me, they are relying on the document of unregistered.
Both the trial court and the first appellate court have relied upon
Unregistered.
record of rights.
Record of rights and unregistered.
Unregistered deed. And your contention is that record of rights only resemble possession.
Regarding possession.
No title is conferred through record of rights.
It is settled law.
And unregistered deed that has no value.
No legal value.
So on the basis of the unregistered deed, one does not acquire any right over the property. So he does not have the right to transfer to anybody else.
And if a document created, that document is void of issue. And nullity in the raising Pakka construction therein, and after the demise of the daughter Sobarani Dotto being the sole surviving legal heir, they inherited the shoot property and used to possess the same, and then by executing registered deed of gift, dated such and such, transferred the shoot property in favor of the defendant, respondent number 1, who is in possession of the shoot property since then, continue without any interruption, paying rent such and such. Well, I am not reading it. transfer date of 21st of March 2023. 1993. When we file the suit, you'll also find initiation of suit, you'll also find
2004,
26th of May 2024. 2004.
2004.
After 11 years.
That is there, no counterclaim. No counterclaim. Your lordship knows that adverse, if any person claim that I am in adverse position, they have to, as per judgment of the Honorable Supreme Court, as per provisions of Section 27 of the Limitation Act, they have to plead the hostile. And my case arose in the cause of action we have stated. When when they started disturbing my position and impose some portion, then we have to file suit. When I shall place the plaint, your lordship will get this. Now, your lordship kindly consider page 20. Who is possessing suit property since then continuously without any interruption by paying rent to the government. Here, the defendant number 1, title interest over the suit property by adverse possession. But when they claim adverse possession, they are admitting my title. A person claiming adverse possession, it is a settled principles. A person's claim adverse possession without claiming title to the party who against whom he is claiming adverse possession, no adverse possession, plea of adverse possession does not lie. There is legal proposition, settled proposition of law. They are admitting when they make the claim of adverse possession, in the evidence there is no pleadings, but in the trial court did not adverse possession. When they are claiming adverse possession, then it is their admission that we are the owner of the property.
Against whom they are claiming?
Plaintiff.
They are in one way they are admitting that he is the actual owner.
He is the actual owner by way of a unregistered deed of gift and also claiming adverse possession. Then they are admitting my title.
No, your contention is that on the one hand, they are claiming the right through unregistered deed of gift.
Unregistered deed of gift.
On the contrary, they are asserting their right through being in adverse possession.
Being adverse possession.
That cannot be.
That cannot be. Cannot blow hot and cold. Appropriate and reprobate. They have relied on the judgment. I am reading 1924 matters. Hearing the instant case, it appears that once this is findings. It appears that once the brother of the Umanath Dotto, namely Bholanath and Phonibhushan, had filed objection against the entry number RSROR such and such, section 44 such and such. The said proceedings, the objection made the said Bholanath and another was rejected by the revenue officer by the order dated 1957. No appeal was filed against the said order. Further, it appears that Umanath Dotto was not a party to the said proceedings.
He has not paid for correction.
It further appears that the said Umanath Dotto was not a party to the said proceedings. But you also can marked it. Admittedly, it appears that Exhibit A is an unregistered document. This is very important. And as per Registration Act, the transfer by a gift of immovable property is to be registered. The appeal court also held. However, as per exception of Section 25 of the Contract Act, nothing shall affect the validity of gift actually made between the donor and the donee. Any gift actually made between the donor and donee. Page 20, last line.
Yes. Actually made between the donor and donee will be valid even though there is no register.
Actually made between the donor and donee will be valid even though there is no registered deed. That's why this substantial question of law has been framed. This is totally wrong. Section 123 speaks about gift of in respect of immovable property. Section 123. And this contract act is nothing to consider here. It will not apply here. There is no application of it is no application in this in the suit in deciding the issues. That's why the Honorable Division Bench, suo moto, in absence of the learned advocate, this is change brief we are arguing before us. After change brief, we got the brief.
Has to abide by the provisions laid down on the Transfer Property Act.
Transfer Property Act. This regarding deed of gift. Any immovable property transferred in respect of sale, Section 54 of the Transfer Property Act, gift deed 123. Hence, in instant case, it appears that Umanath Datta had never challenged the Exhibit A. I am not a party to these proceedings.
That you have stated earlier.
And during the lifetime, it further appears that from Exhibit E series that there was no proceedings initiated by Bholanath Datta, Konibhushan Datta, under Section Exhibit E series that there was a proceedings initiated by Bholanath Datta and Konibhushan Datta under Section 44(1) of the West Bengal State Acquisition Act. The revenue officer was pleased to reject their objection by the order dated such and such, but no appeal was been filed by them at any point of time against the said order. Further, in present the case, the plaintiff have not challenged their challenge in their plaint about Exhibit A. But a unregistered document, it is my duty to challenge. When the document itself is bad, no legal value, the question of challenging, question of setting aside does not arise. Unregistered document is no way valid in the eye of law. From the same, these observations are totally perverse, based on no evidence. From the same, it can be considered that Umanath Datta and his two brothers duly executed Exhibit A. But how? Umanath Datta has not executed unregistered gift deeds.
Yes.
During their lifetime in favor of Subhashini Dashi. Further, it appears from the oral testimony PW1 at the time of cross-examination, the admitted on the said land has been made by Shobharani Datta and said that she, along with Shobharani Datta, had made construction. However, it is not the case of the plaintiff. PW1 has made construction on the shoot land as per the plaintiff's case. Umanath had made pakka construction after getting the shoot land by way of amicable partition. I have already held that there is no evidence on record from the side of the plaintiff established about the alleged amicable partition. In the instant case of the plaintiff have paid for recovery of first possession along with the declaration of the title over the shoot property, but the plaintiff have failed to state that when they were dispossessed from the shoot property by the defendant, and further, I have not stated that I have disposed. My case that I have I permitted them, their predecessor. When her husband died without issueless, she was brought.
She was granted Shobharani was granted
to
permissive possession.
To take shelter as early age he lost
during her mid age
he lost her husband without issueless, without any issue. That's why we have allowed to stay. Now this is the total. There is no legal. Section 34 also does not apply here. Well, there is a prayer for recovery of possession. Declaration and recovery of possession. Without recovery of possession, I have not paid for. There is a prayer for recovery of possession.
Yes.
Now you also kindly visualize the entire picture. Very short campus. Admittedly, our three brothers were the owners. Our case that we got the property by amicable oral partition, and my other brothers got other properties.
This property
One decimal.
was obtained by
Amicable.
Umanath Datta through amicable partition.
Amicable partition.
And thereafter, his Bhagni Datta
was allowed to stay.
Was allowed permissive possession.
And taking advantage of that, they procured the alleged unregistered deed of gift and
On the basis of the unregistered deed of gift.
And recording her names, and we have not challenged their names.
On the contrary, the name of Umanath Datta has been made being in permissive possession.
Permissive possession in the arrest record, but in CS record, name of Umanath was there.
In the CS record, what was the actual? Actually, there was the
three brothers.
Umanath
and they have admitted.
Ishtopada
and they have admitted that I am the owner. That's why they have also claimed adverse possession. And my other brothers were pro forma dependents.
Yes.
And if any decree be passed for eviction and recovery possession, that will be benefited to other co-sharers, if there be any at all co-sharers.
Other co-sharers?
Pro forma dependents, from whom they are claiming unregistered deed of gift.
Anything apart from citation? Anything more?
I will frame two substantial question of law. Other two additional substantial question of law.
After recess. Let us come back after recess.
After recess, not.
Yes, Mr. Datta. Being inspired by your advocate on record, you are submitting further submission.
No, advocate. He's not advocate on record. He's counsel. Advocate on record is other junior. But I will make it photocopy to the judgments, and while on the tomorrow you'll also kindly have it.
Why not today?
There are many judgments here also, and while another court number 6, court number 2. Court number 2, my most.
As regards the court number, also you require assistance.
No.
My lord, the seniors always forget, my lord. The juniors are there too.
Court number 2, my lord.
I'm digesting.
And I have to make endorsement in the.
Yes, obviously. That will have to be done during the course of this day.
In course of this day.
Can 5 of 2020.
5 of 2020.
23. এটা পার্ট মনে হয় উনি নিয়েছেন বুঝেছেন বাকি পার্টটা
item number 7 also, my lord. If you lordship accommodate today, tomorrow I shall make my submission, my lord.
This one is item number 5.
Item number 7.
When called, let there be.
My junior will be here. Item number 7.
The learned senior counsel commences his submission. Commences his submission.
Tomorrow, my lord.
বন্ধ করুন
Number 6, I am appearing on behalf of the appellant lordship. In the earlier occasion, my argument was completed. Only to refresh your mind, I can start lordship. Mr. Gopal Ghosh is my
Yes,
answer.
Mr. Gopal Ghosh,
He was there,
he was there.
prior to the recess.
Acha.
Well, let the matter may be short passed or not today.
No, no. Short passover. The passover था. दिन.
मैं बोलूँ तो ना क्या बोलूँ तब तो खुदा है
Oh. Ms. Sarkar, some recapitulation is required
Yes,
because it took place few months
long
ago.
back, lordship. Yes, long back. Well, in a very nutshell, I can place before your lordship that my case is that there is a partition deed, and in the partition deed there was a typographical error.
Hmm.
And what is that typographical error? The dark number is
There's a
uh,
paper book.
yes, I have a paper.
Paper book. Second level প্রশ্ন
একটাই
paper
paper
book
book আছে।
paper book এই সবগুলো অর্ডার দরকার নেই।
নম্বর ফিক্স করে আছে সেখানে
Yes.
I'll come to page 41. That is the
Hmm.
order of justice, the order of the division bench, Justice Harish Tandon and Justice Showmention and Justice
Ajay Kumar Mukherjee.
Ajay Kumar Mukherjee.
5 substantial questions.
Well, aligned my second appeal, the order was passed, my lord, but I am placing that order. In view of the fact,
No,
second appeal allowing second appeal no admitting
admitting. Place the substantial questions of law.
yes, page 41. Can you come to page 41 of
Whether the first appellate court has committed
whether the first appellate court has committed substantial error in law in failing to appreciate that from the title deed of the appellants and the title deed of the predecessor in interest of the appellants clearly established that the appellants have right, title, and interest in respect of the suit property. Number 2, whether the first appellate court misconstrued Exhibit 2 and B in arriving at a finding that the plaintiff have right, title, and interest in respect of the suit property. Whether the first appellate court misconstruction of exhibit D, E, and H and misappreciation of evidence has returned the finding that the plaintiff are the owner of the suit property. Whether the first appellate court has committed substantial error in law in not appreciating that the Honorable High Court by its judgment and order dated 13th May 2025 in FMA 558 of 2013 has clearly decided that the registered deed of conveyance dated 29th October 1999 and the rectification deed dated 18th June 2001 executed by Renuka Rani in favor of the defendant cannot be challenged by the plaintiff. And my lord, kindly turn to page 42, my lord. Serial number 5, whether the first appellate court would have ignored the judgment and order dated 13th May 2015 in FMA 558 of 2013, which established the right, title, and interest of the appellants over and in respect of the suit property. All for the records issued. These are the 5 substantial questions of law. My specific case is that there is a typographical error in the partition deed in the year 1968, 1960, I think so. And what is the error? Error in my DAG number. But boundary, whatever the mention against the DAG number, boundaries are absolutely correct. But there is a typographical error while writing the DAG number. This is my specific case. And my lord, I am placing for that reason, the suit was filed by Dilip Kumar Datta, Uttam Kumar Datta, and I was the respondent or dependent on that suit. My lord, I am placing the trial court's order. My lord, starts from page 1.
Need not place the entire order. Error in the DAG number. In which exhibit?
My lord, I am placing. My partition deed was exhibit 1.
So there was error in the DAG number mentioned in exhibit 1.
Exhibit 1 is my partition deed. My lord, I am placing the page 10. From page 10, no, page 9.
Page 9. Yes. Place.
Page 9. From the top of it. On one hand, plaintiff claimed that since the LR record of right stands in their favor, as such possession stands in favor of plaintiff. The plaintiff also claimed that exhibit 2 in their main title deed on the basis since LR record of right was made, but due to mistake of deed writer, the entire confusion has cropped up. The defendant, on the other hand, claimed that Pachkoripal was in the exclusive possession of co-scheduled property along with some portion of southern side of plot number 1090. Well, the plot is a L-stretched plot. L-stretched plot. Well, I have given your lordship a map.
দিন তো দেখি envelope আছে, envelope কিছু আছে, envelope. Has any map been annexed
One
with
photograph.
Has any map been annexed with the plaint? Does the plaint bear any photograph?
No, that I have to check because I forgot.
Yes, plot number 1090.
Yes.
So Ghosh, you have copy of these 2 documents? You have copy?
No, let me check.
একবার একবার ওনাকে ওনাকে দিন তো গোপাল গোপালকে দিন।
I put the
Yes.
plots are there. One Bata plot 1085, Bata 2969. That Bata plot has some problem because deed writer has wrongly recorded the Bata plot number in the partition deed.
Instead of that, what should be there?
Instead of that, but the boundary, whatever the written in the partition deed is absolutely correct.
Butted and bounded, whatever has been mentioned under the heading butted and bounded is
Butted and
absolutely correct.
Boundaries are absolutely correct. Only there is a typographical error in the dark number.
Instead of 108529 by 2969, it ought
They
to
have
be
written 1090.
1090. The correct one is 1085.
1085 Bata 2969. Or may I start?
1 minute. This deed was registered when?
My lord, this partition deed was registered in the year 1960. 69. On behalf of the defendant party, the execution of deed of Pachkoripal in favor of Renukarami was 61.
1961.
Yes. Well, unless the entire trial court's order is being placed before your lordship,
Please, place it.
well, may I start from the beginning?
Not from the beginning, from
Page number 9. 61, the partition deed was 61. The partition deed was made. Thereafter, Pachkoripal transferred his share to Renukaranipal. I purchased the property from Renukaranipal.
Please.
Next paragraph. The defendant, on the other hand, claims that Pachkoripal was in exclusive possession of co-scheduled property along with some portion of southern side of the plot of number 1090. As such, they are in possession of the same. The defendant also claims that Pachkoripal, while in possession of the property, sold the same to Renuka Chaudhary, who subsequently, with the passage of time, sold co-scheduled property to the defendant. The defendant also claimed that the Eller record of right is void and it is not made in actual possession. Now the court has decided whether the claim of the respective partition deeds have been substantiated by them or not. Before going deep in the matter, it is prudent to mention that the settlement of record neither create nor extinguish any title. It is merely a document of possession and it is settled law that a person in whose name the settlement record stands leads to presumption that he is in possession of the suit property. It is also prudent to mention that every presumption is rebuttable and presumption loses its weight if it is not substantiated by cogent title deed. Accordingly, the Eller record of right as produced by the plaintiff would have been standing in the solid platform and had there been strong backing by cogent title deed because settlement record of right also stands of foundation of some cogent title deed. In the present case, the LR record of right only gains importance if it is backed by any title deed. In the present case, let us see as to how far the plaintiff has substantiated the title deed and the actual possession. It is also prudent to mention that plaintiff have to prove their own case. The plaintiff can't bank on the strength or weakness of the defendant. In the present case, plaintiff have came up before the court with a prayer for declaration that they have right, title, and interest and possession over the co-scheduled property. And as such, the burden heavily lies upon them to prove that they indeed have better title than anybody else. In the present case, the plaintiff claimed that Shatkori, while in possession of the co-scheduled property, along with some other portion of plot number 1090, sold the same to the Datta brothers in the year 1969, wherein 25 Shotomik was sold to them. It is admittedly that the co-scheduled property is 17 decimal. Of 17 decimal of land, then the remaining of 08 decimal of land as per plaintiff is in plot number 1090. The defendant, on the other hand, claims that the plaintiff have not purchased any property from Shatkori Pal because Shatkori Pal was not at all possession of the suit property along with other properties, which he has sold to Datta brothers because in reality it was Pachkori Pal who was in possession of the suit property and other properties in plot number 1090. And prior to the execution of the Kobala in favor of Datta brothers, the Pachkori Pal had already sold the property in favor of Renuka Chaudhary in the year 1969, and Datta brothers got their property in the year 1975.
Pachkori sold
in the year 1969 to Renuka Chaudhary. I purchased my plot from Renuka Chaudhary.
(1969).
60.
Yes.
Consider, it seems upon perusal of the documents that Renuka Chaudhary's deed, that is Exhibit B, is executed much prior to the deed of the Datta brothers. As such, the ordinary presumption leads to conclusion that Pachkori Pal sold the property to Renuka Chaudhary while in possession of the same, because that is the deed Exhibit B. Exhibit B is the deed where Pachkori Pal sold the 1969's deed. Shows if the plaintiff are asserting that the deed in favor of Renuka Chaudhary by Pachkori Pal is invalid, then the plaintiff have to pray for resumption of the same. Repudiation of the same. Now let us see as to how far the plaintiff have proved their own positive case. The real matter in controversy, it is very much important for the court to come to conclusion as to whether Pachkori Pal was in actual possession of co-scheduled property along with some portion of plot of land, the portion of plot number 1090, or whether Shatkori Pal was in actual possession of co-scheduled property as claimed by the defendants. Because this assertment of acquire is very much essential for the respective parties and their subsequent claim. It is perceived upon perusal of Exhibit 1 or Exhibit M that the co-scheduled property in the partition deed of Pachkori and Shatkori was allotted to Shatkori Pal, whereas the co-scheduled property was allotted to Pachkori Pal.
Yes, sir.
It is also perceived on the perusal of the partition deed that on the southern side of the two rooms are corrugated tin shed. Well, kindly come to the photograph. Not that photograph, not that.
Which one? The colored one?
Color one.
Yes.
My lord, that southern part, my lord, there was written Dokkhino Purvodari Pokta Du Ghor, Dui Kotori Mae Somukh Soho Corrugated Chala Ghor. I am referring that portion. Also perceived on the perusal of the partition deed that on the southern side of the 2-room or corrugated tin shed, which is allotted to Pachkoripal, it is also perceived that the co-scheduled property was exclusively allotted to Pachkoripal. Kindly come to page 11.
Yes.
In the cross-examination, of PW1, it is admitted that on the north of plot number 1090, north of plot number 1090 lies a separate plot, that is plot number 1090 Bata 2970. On the south of plot number 1090 is a PWD road. Kindly come to the It is also forthcoming on the perusal of evidence of PW2 and PW3 that on the north of plot number 1090 lies plot number 1090 Bata 2970, and on the south of the plot number 1090 is a PWD road.
Now, on perusal of the evidence of plaintiffs and defense,
Yes, Lordship. It is also forthcoming on the perusal of evidence PW2 and PW3.
That on the north of plot number 1090
lies plot number 1090
1090 by 29070.
Yes.
The south of plot number 1090 is the PW road. It is also perceived on the perusal of the evidence of PW2 and PW3 that
Bholanath Kamilya has a house in plot number 1085. That is upper portion of that plot 1085 Bata 2969.
Yes.
In the other word, it is clear that on the north plot number 1085 Bata 2969 lies a house of Bholanath Kamil. On perusal of evidence of plaintiff and defendants, one thing is very much forthcoming, that is, topography of the land as given by the evidence corresponds to that of co-scheduled property of the partition deed of Pachkoripal and Shatkoripal. The learned lawyer on behalf of the plaintiff draws the attention of the court that Exhibit J series, that is LR record of right as produced by the defendant, and claimed that as per documents of defendants, the plaintiff's case is admitted. I think that let us give an audience to the learned lawyer and scrutinize those documents. On perusal of Exhibit J series, plaintiffs are trying to blow hot and cold at the same time. If the record of right is recorded in the name of Dilip Dotto and Uttam Dotto, and that on the same hand, it is also recorded in the name of the Renuka Chaudhary. In other words, the claim of the plaintiffs regarding Exhibit J is nullified by Exhibit J itself, because as discussed earlier, the document of settlement neither created nor extinguished. The learned lawyer on behalf of the plaintiff also argued the Kovala of Renuka Chaudhary in favor of defendant is silent about their status as tenant. The learned lawyer on behalf of the plaintiff also argued that the rent received as produced by defendants are collusively obtained. I am of the opinion that the plaintiff are trying to suppress and cover its own lacuna by highlighting and finding defeat of the defendants. Plaintiff are claiming possession by showing the LR record of right. Then in such a facts and circumstances, the plaintiff have to show the foundation on the basis on which the LR record of right was prepared. On the emphasis in the word foundation, because either parties are claiming possession. But kindly come to page 12. In my sense, foundation means the cogent title deed. On one hand, the plaintiff claimed that there is an error in the partition deed regarding the mention of co-scheduled property in favor of Shatkoripal, whereas on the other hand, the LR record right has been obtained in the name of plaintiff. In other words, the plaintiff can't satisfy the court as to on which basis the plaintiff have produced the LR record of right as specifically when the possession is claimed by either parties. On perusal of the documents as furnished by the rival parties, that plaintiff are not only claiming possession over the co-scheduled property, but also in some portion of land which is situated in plot number 1090. The defendant, on the other hand, claimed that co-scheduled property along with the land in plot number 1090, which has been claimed by plaintiff, are not genuine because the plaintiff were not at all possession of the co-scheduled property. If that be the situation, then the plaintiff ought to have brought the clear picture by taking the assistance of survey pass commissioner, because the boundary dispute has been raised by the defendant. The plaintiff can't bank upon the weakness of the defendant because the plaintiff have to prove their own case. There is no explanation on the part of the plaintiff as to why the plaintiff did not pay the conducting commissioner in respect of suit property of survey pass commissioner when the dispute is raised in regard to possession and regard to boundary. Upon panoramic perusal of Exhibit 2 and Exhibit B, it is perceived that Exhibit B, that is document which was executed by Pachkori in favor of Renuka Chaudhuri, have an age that Exhibit 2, that is the deed which is created by Shatkori Pal in favor of plaintiff, because Exhibit B executed much earlier to execution of Exhibit 2. And law is very much settled that a document executed earlier in time will have a preference. On perusal of Exhibit B, which is executed earlier, it seems that Pachkoripal had already washed his hand in respect of co-scheduled property in favor of defendant's vendor much earlier than Shatkoripal sold the same to plaintiff. The description of property which sold by Pachkoripal corresponds more comfortably over the property which the defendant are claiming to bear. Subsequently, schedule of Exhibit 2 does not correspond with co-scheduled property. Now can we come to page 13? The LR record of right as produced by plaintiff can neither create nor extinguish the title and merely a document of possession. The LR record of right can't be considered to be a gospel truth.
Time and again, same thing has been stated.
Yes, Lordship. Then I issue number 6. The one thing, right? Kindly come to page 5. What are the issues? My lord, my main issue is issue number 6 and 7. Have the plaintiff any right, title, interest, and possession over the suit property? And 7, are the plaintiff entitled to get degree as spread? These two issues. My lord, I'm coming to that issue. That is page number 13. My lord, issue number 6 and 7. On perusal of the plaint and injunction petition and also on perusal of the documents, it can be concluded that the plaintiff came up, it can be concluded that the plaintiff came up before the court with the prayer that defendants have no manner of right, title, and interest and possession over the co-scheduled property. The plaintiff also laid to claim that due to mistake in the partition deed of Pachkori and Shatkori, subsequently mistake was already put down to the other deeds. The plaintiff claimed that the mistake on the partition deed is bona fide. The defendant, on the other hand, claimed that the plaintiff have filed a false and frivolous suit and they are in possession of co-scheduled property. They are in possession of the co-scheduled property. On perusal of the above discussion, I am of the opinion that plaintiff have failed to prove that they are in possession of the property in dispute. I am also of the opinion that the schedule of the plaint does not reflect and corroborated the claim of the claim and actual topography of the property in dispute. The law is very much settled that where the subject matter of a suit is immovable property, then the description of the property is sufficient to identify it, and in case of the property can be identified by boundaries or no, or not. In regard to settlement or survey, the plaintiff was specified such boundaries or numbers. Boundaries or numbers. The plaintiff was specified such boundaries or numbers In other words, the description of the property should be very much clear because description of the property should be sufficient to identify. In case of such property by boundaries or numbers in survey record, the description of property is sufficient to identify its essential. In case such property can be identified by boundaries or numbers in survey records, such boundaries and numbers should be given in plain in respect of immovable property. It is the duty of the court to pass only such degree which can be executed with all precision and without any confusion or embarrassment either to the executing court or to any person. Hence, recapitulating all aspects, I am of the opinion that the plaintiff have failed to prove their case. As such, I am not inclined to pass decree in favor of the plaintiff. My lord, can we come to the appeal court, sir? This is the order of reversal. My lord, I made a mistake, my lord. For that, I seek pardon, my lord. That 1961 would be Pachkori sold to Red.
Not 1969.
1969. And the defendant Shonatan Shah purchased the land from Renuka Ranipal in the year 2000.
That is also wrong.
Satkori.
Can you check? Don't see anything outside.
Okay. But I have, in the earlier occasion, I have handed over a list of dates, Lordship.
দেখুন আর কি আছে আর কিছু আছে কি এনভেলপে আর কিছু আছে কি এটাতে কিছু আছে এটাতে কিছু নেই apart from these two
না না আমি তো 3টের সময় চলে যেতাম
My senior has a
বলুন বলুন
this one is the list of dates typography is not in the normal format.
no, my lord, that is not.
Wherein the dates are mentioned, I think.
I have only one copy. Let the matter be not to the, so I can make all the documents available for the court. A second.
দেখুন থাকবে যাবে কোথায় দেখি এটা দেখি দিন এরপর যদি পেপার কিছু হারিয়েছে তাহলে কিন্তু আপনাদেরই ধরবো কিন্তু কি ঠিক করে দেখা হয় না কেন বা ঠিক করে রাখা হয় দেখি এটা এনভেলপ দুটো No, it is not there. It is not.
But I have a one copy. Well, let a chance be given to that I will prepare all the copies at the second time. Then I will produce.
Only that list of dates.
Well, list of dates is very important because.
Yes, apart from that, nothing more to be provided. List of dates you have provided, you have with you.
I have one.
Photocopy, yes, a photocopy will have to be provided. That can be provided tomorrow itself.
Yes, my lord, I am seeking tomorrow, hearing of the matter for tomorrow.
Let us take up the judgment of the first appellate court.
First.
On which ground it has reversed.
My lord, the issues are written in at page number 22. The issues are framed by the learned trial court.
No, need not place the submission of the learned counsels thereafter.
All right, then I have to place the decision with reason.
Yes, yes.
First and foremost, I took all right, point number 1 is not relevant, maintainable in the present form and prayer. As the suit any cause of action. Point number 1, 2 is not relevant. Is the suit barred by?
No. Eখানে point formulate for page 23. Whether and with
Now at page 23, Lordship.
Which page there is the discussion?
Well, at paper book, my lord.
No, in which internal page of the said judgment there is a discussion about the dark numbers. I think from page 24 1C, the Lorette Civil Judge Junior Division Ghatal on meticulous.
At 1B also have some discussion about the dark numbers.
Place from 1B.
I am placing page 23, decision with reasons.
Need not place point number 1 thereafter.
Point number 1B.
Yes, 1B.
In the instant appeal, it is the admitted position that the suit dag number 1085/2969 and the non-suit plot 1090 was owned and possessed by Shatkoripal and Pachkoripal. The plaintiff appellant have asserted that through the partition carried forth between Pachkori and Shatkori, it was Shatkoripal who had gained right title and interest over the entire constituent property, being the suit plot number 1085/2969. While the defendant respondent have asserted that through such deed, it was Pachkoripal who had become the owner of the entire co-schedule. If the rival assertion are considered, it would appear that fate of the suit had depended only upon the question as to who among such two brothers had gained right title and interest over the co-schedule. If it be that it was Shatkoripal who had gained right title and interest over the entire co-schedule through the deed of partition, the plaintiff appellant would have a success in the deeds. On the other hand, if it be proved that it was Pachkoripal who had gained right title and interest over the co-schedule, the plaintiff appellant would stand entitled or to any relief claimed by them. The learned civil judge Union Division had framed an issue to which whether the co-schedule property was allotted to Pachkoripal or Shatkoripal. As determination of such issue is one of the vital questions occupying a major part of the instant lease. I proceed to look into the judgment coupled with the evidence so as to determine whether such issue had been correctly pondered upon and decided by the learned civil
These
judge.
are all literature. Where is the crux of the
1D.
first appeal?
Kindly come to page 25.
Yes. It is next pleaded.
It is next pleaded by the plaintiff that Shatkari Pal had sold the entire co-schedule to the plaintiff and one Shondit Dotto, but due to the error of the deed writer, it was stated that a consolidated 25 shatak comprising of land within the suit plot and also the non-suit plot 1090 was sold to them. From the recital of such deed, it would appear that the land sold along with the Pakka residential house was included in DAG number 1085 and 1090 DAG. It is further stated that the DAG 1085 was divided into DAG 1085 Bata 2969 and DAG number 1090. The recital also stated that through the partition, the joint properties of Pachkori and Shatkori was partitioned and the deed scheduled construction along with 25 shatak was allotted to Shatkori Park. It is also stated that the residential house sold situated.
The partition deed is exhibit.
Huh?
The partition deed, which
One.
exhibit 1.
It is also stated that the residential house sold situated within DAG number 1090, but due to an error, it was written that such residential house situated within DAG number 1085 Bata 2969, and such was completely erroneous. In such deed, therefore, the said Shatkori has stated that the construction allotted to the through the partition deed actually situated within DAG number 1090, but such was inadvertently and erroneously written as being situated over DAG number 1085 Bata 2969. It is herein where the crux of the dispute lies. If the partition deed is scrutinized, it would appear that it was stated that 1090 দাগে দক্ষিণ দুয়ারি নিচ উপর দুই কুটুরি পোক্তা গৃহ মায় হল ও বারান্দা সহ ও পশ্চাৎ দিকে মাটির দেওয়াল করবেটেড সাধান বিশিষ্ট প্রাচীর বেষ্টিত গৃহাদি মূল্যে 4000 টাকা is included in co-schedule deed property. Malad, kindly consider my photograph.
Yes.
দক্ষিণ ও পূর্ব it was written দাগে দক্ষিণ দুয়ারি নিচে উপরে দুই কুঠুরি. Malad, kindly come 1090.
Plot number 1090 on the southern portion.
Yes. দাগে দক্ষিণ দাঁড়ি নিচে উপর দুই কুটুরি পোক্তা গৃহ মায় তল ও বারান্দা সহ is included in co-schedule deed property. In the co-schedule deed property, it is stated that 10852969 দাগে দক্ষিণ ও পূর্ব দুয়ারি পোক্তা দোয়ার দুই কুটুরি মায় সম্মুখস্থ corrugated chala ঘর and such.
That is on the western side.
Yes. That is plot number 1090.
1090.
Yes. দক্ষিণ ও পূর্ব দুয়ারি পোক্তা ঘর ও দু কুটুরি মায় সম্মুখ সহ corrugated চালা সহ ঘর.
Which was allotted to Shatkori Pal.
Shatkori Pal. In the co-schedule deed property, it is stated that 10852969 দাগে দক্ষিণ ও পূর্ব দুয়ারি পোক্তা দোয়ার দুই কুটুরি মায় সম্মুখস্থ corrugated চালা ঘর and such was allotted to Shatkori Pal. Therefore, there is the error that 1085, the DAG number was written 1085 Bata 2969. Actually, it was 1090. But appeal court holds the reverse part. Trial court holds the same correct one, but appeal court
according to you
findings holds the. Therefore, it would appear there as such and such was allotted to Shatkori Pal. Therefore, it would appear constructions existed over both the DAG being DAG number 1085 Bata 2969 and DAG number 1090. Therefore, through the deed bearing number so and so for the year 1969, it appears that Shatkori Pal has stated to have sold a portion of DAG number 1090. In the deed of the Dotto brothers between the Shatkori Pal, between Dotto brothers and Shatkori Pal, there is also an error. There is also an error because they purchased there was written that they purchased 0.25 decimal of land, but it was not right, not the right point was written, right.
Actual measurement was not met.
Written, because in my further submission, I will satisfy your lordship
Through
that
that deed, through
what
that
are the
deed,
entire plot,
through that deed, whether larger portion was granted or lesser.
8 decimal was in dispute. Therefore, through the deed bearing number so and so, it appears that Shatkori Pal has stated to save
Be kind enough to place the cost schedule and the cost schedule of the partition deed
partition
of the exhibit
partition
1.
was handed over
ওই, কি বলে document কোথায় আছে? In a tin box or covered file? দেখুন তো exhibit গুলো 1 2 3 4 ABCD.
Well, there was a compilation of documents where all the
No.
deeds were.
Let us go through the exhibited documents.
Yes.
Are those in the record or withdrawn?
All are in record.
All are in the record.
Partition deed is exhibit what?
Right, trial quoted TS রেকর্ডটায় এক্সিবিটে যান, এক্সিবিট গুলো দেখুন, এক্সিবিট 1 2 3 4 ABCD. দিন দেখি। ডিপোজিশনের পাওয়া যাবে, ডিপোজিশনের পরে থাকবে। টাইটেল অ্যাপিলটা কেন? Yes, exhibit A. You have provided, or whoever has provided a photocopy. Exhibit 1 is the partition deed between Shatkori and Pachkori. And what is the demarcated map?
My lord, demarcated. That time no map was found.
How can it be?
Map was there.
Mr. Ghosh, how can it be? Partition deed
Map is
without bearing any map.
Map was not annexed.
Then this situation will arise. It is not mentioned.
No, man.
Red color, yellow color, green color.
Your lordship got this deed.
Yes, a photocopy of a certified copy. Photocopy of the volume copy.
And the earlier authors of that dispute was but there is no map in the partition.
Both of you possess the partition deed, a copy of the partition deed. I think so.
Lord, I shall try to produce if it is available to my client. He has not come today. All on a sudden the matter has appeared. It disappeared from the list, though my lord fixed the matter on 7th. But it disappeared from the list. All on a sudden it has come today.
If
That's
such things reveal, mention it.
No, but it was not written seventh on the, in the order, no. It was written when the single bench is available.
No, no. On that day you were not there, my lord passed an order.
Order হয়েছে তো,
হ্যাঁ,
order এ
দেখেছি।
তো তাই লেখা আছে।
My lord has recorded an order. Order আছে।
আচ্ছা,
Order is there.
so first of all, there ought to be a map along with the partition deed. Otherwise, how can one see who was allotted A for A lot A, who was allotted lot B? What is exhibit 2?
Exhibit 2 is the deed between Pachkari and
Creta is Dilip Kumar Dotto. And Bikreta is Satkori Pal.
Yes, that is in our favor.
Yes.
And exhibit 3 is councils. These deeds are to be translated. First of all, written in Bengali, not typed, handwritten. It is
No, I will supply your lordship the typed copy. I have got the
very much
typed copy. I have
difficult.
typed
Not
copy.
difficult, it will take
Much.
double the time,
Yes.
which is to taken generally.
Lord, so far the deed is,
Hand
as far as it is concerned, there is no mention of any plan or sketch map.
Sketch map
Nothing.
is-
Nothing is there. And the handwritten deed is not the handwriting is very
Yes.
difficult to.
If a senior counsel like you say so, then
Lord, your lordship, I have seen, that's right. However, Lord, I have.
much difficult to.
Yes. Lord, I have got a typed copy. I will give
So,
you, provide you.
can the typed copy be provided of exhibit 1,
Yes.
2 and 3?
Yes. All.
When?
Lord, give some time, Lord.
How much?
When is the next week?
Weekend?
We can do shall try to it. But Lord, your lordship can you fix on 19th.
Why not on 17th?
Lord, 17, 18, I will not be here. That's not told. 19th or 20 in day.
19th. Let it be on 19th. And Ms. Sarkar, after receiving a copy be provided to her also?
Yes.
Ms. Sarkar, go through the. She is smiling. She is smiling. Go through the copy also. That is fact. You were the plaintiff before the trial court.
I have to type.
You had to provide.
Yes.
I had to. My senior will provide me.
No,
That
no,
is why I'm
if it
lying.
is originally if it is in your possession,
I don't have the
Then-
copy. I have to type.
Lord, I shall try.
Learned counsel representing the appellant. Appellants commences his submission. But during the midst of submission, it transpired that the documents exhibited, specifically the exhibit 1, that is the partition deed, which is the fulcrum of this list. If you will see your fulcrum of this deed. Um, and the exhibit 2 and exhibit 3. Exhibit 2 is a cell deed, exhibit 3 it is also a cell deed.
Yes, sir.
One cell deed is
By
Shantanu Pal,
Sathuri.
Dotto Brothers, and one Renuka to
Pachkori to
Renuka, and another one is Renuka to Sonatan Shah. And
no.
there
It
are
is
four
one of
deeds.
একটা mysterious deed আছে।
one হলো
তো 2 নম্বরই করে তৈরি করেছে।
address কি হলো?
একটা আছে mysterious deed।
Means of submission that the document exhibited specifically the exhibit 1, that is the partition deed, which is the fulcrum of this deed, and the exhibit
List LIS deed na, of this list, fulcrum of this list.
and the exhibits 2 and 3.
2 and 3. আরেকবার list of
And the council representative that this submission, but during the midst of its submission, it transpired that the documents exhibited specifically the exhibit 1, that is the partition deed, which is the fulcrum of these deeds, and the exhibits 2 and 3.
Exhibits 2 and 3 are handwritten, those are the typed copy of those are required. Full stop. At this juncture, learned senior counsel representing the respondents.
Yes.
Respondents submits has been candid enough to submit that he is in possession of typed copy of those deeds. Full stop. And full stop and will furnish them on 19th of August 2026. Full stop. Paragraph accordingly, let the matter be fixed on 19th of August 2026. Ms. Sarkar, you will provide the list of dates.
Yes, Lord.
Let those be exchanged among yourselves.
I will provide all the documents which I will provide.
Yes. দেখে দিন বুঝলেন, পরে একটা দেখে দিন, দেখে দিয়ে তারপর নিয়ে গুছিয়ে নেবেন।
My lord, I am appearing on behalf of the appellant.
Well, I am for the respondent, madam.
Appeared in this matter in item number 5, and today he has prayed for an accommodation. Make it not today, madam.
Who is the advocate on record? Who is the advocate on record on behalf of the appellants?
He is our junior.
Where is the advocate on record? Where is the advocate on record?
He is there outside the.
Fair enough on his part. ওনার নামটা নিয়ে নেবেন। Learned advocate representing the appellants seeks an accommodation on the ground of the learned senior counsel for this day.
Yes, sir. I am saying not today.
Let the matter appear
An accommodation on the ground of the council
for this day. Considered allowed. Let the matter appear tomorrow. That is
I am for the respondent.
13th of August.
Tomorrow.
Tomorrow it will appear.
Get. May I give the name, madam?
Yes, of course.
Okay.
You are present, why not?
Okay.
Learned counsels, during the course of this day, go through the entire record, whether all the documents are there or not. Otherwise, in the midst of hearing, if such circumstance arise, it is not.
At the time of
Mechanism.
admission, my lord, the division
No,
bench,
at the time, when it has been admitted,
well, in 2022, my lord,
2022.
1/9/2022, and that time, my lord,
4 years,
possibly,
4 years have passed by.
possibly record has not
Kindly-
called for, my lord, that time. If possible, then if required, then, my lord, as because that is a corona time, my lord, that's why. That,
देखिए
that already was there. Possible.
देखिए दिन पर ना अरे 7th दिन the trial court record and the first appellate court record have not arrived.
Possibly, my lord, kindly see, my lord, 1/9/2022 order, my lord, kindly see admission order.
1/9/2022.
Yes, ma'am.
Three substantial questions
Yes,
have
yes,
now
yes.
been framed.
Yes.
Whether the learned judge of the first appellate court erred in law in not appreciating that the suit for declaration filed by the respondents plaintiffs was barred under section 4 of the Benami Transaction Prohibition Act. Whether the learned first appellate court erred in not appreciating that the respondents plaintiffs could not acquire any title by operation of the above act. So Benami Transaction Act, section
Yes, yes.
4. Whether the alternative claims made by the respondents plaintiffs in the suit were not maintainable in as much as the claim to title alternatively by adverse possession is contrary to the claim of the respondents. If the respondents are not represented, let a formal notice of the transmission of lower court records is dispensed with for the time being. If required, we shall call for them at the latter point of time. Which
My lord has also heard this, my lord, before, my lord, once, my lord. My lord has passed an order, my lord, my lord, the
directing what?
interim order, my lord, till the disposal, my lord has done that. And thereafter, my lord in the division bench, that's why it was not hard, my lord.
Without going through the trial court and the first appellate court.
My lord, we have the record with us, my lord. Kindly hear me. Thereafter, my lord, if possible, my lord. We have the
Senate Counsel, come prepared tomorrow.
yes.
You have the plaint?
Yes.
Copy of the plaint, copy of the written statement.
Yes, my lord. Yeah.
Trial,
And also
trial
the
court judgment,
exhibit.
trial court judgment.
Yes.
Exhibits.
Yes.
All the exhibits.
Yes.
And the first appellate court judgment.
That is it.
Be kind enough to provide a compilation of that. And provide a copy of the compilation.
They have with us.
Your paper book is already on record.
Paper book is already.
Yes.
Paper book, देखिए paper book देखिए. Paper book देखिए 7 है paper book देखिए.
Paper book is there, my lord. They have.
Benami transaction and adverse possession.
Yes, yes.
পিয়ন কোথায়? Judgment decree, plain written statement and the exhibits.
I will go. Exhibit I with me, madam. All exhibit.
রেখে দিন item number 7 পরেরটা ডাকুন
And tomorrow.
yes tomorrow
Get.
order হয়ে গেছে না 7 এ?
Item number 8.
At item number 8, I am appearing on behalf of the appellant, but I have contacted my learned senior friend, advocate, which will appear on behalf of the defendant lordship, the senior advocate. He died somehow in last year. So thereafter, I have contacted her daughter, whether you will hold the brief or not. She told me
who is Habiba Khatun? You.
she is my junior. Today I also contacted with the advocate.
On behalf of the respondent Alok Rai Chaudhary and Anindita Rai Chaudhary were
Rai Chaudhary died somehow in last.
Achha.
And I have contacted her daughter, that Anindita Rai Chaudhary. She told me that she will present today. But today I have contacted him twice, but she never
Responded.
So kindly, one day accommodation be given. I will have a talk with her that whether she will hold the brief or not.
During the course of this day?
Yes.
And apprise the court tomorrow?
Yes.
Name. The learned advocate, but learned counsel representing the appellant submits that the learned senior counsel representing the respondent has expired and she has expired and she has contacted the learned advocate on record on behalf of the respondent. Full stop.
Yesterday she informed me that I will be present today, but today when I call her, she never.
Paragraph. At the time of call, none is representing the respondent. In such situation বা circumstance, circumstances করবেন না, in such circumstance, যে কোনো circumstance হচ্ছে সবকিছু নিয়ে পরিস্থিতি. In such circumstance, let the matter be taken up tomorrow, but that is হচ্ছে 13th of August. Learned counsel, it will be better if you serve a.
WhatsApp.
You can. No. If you can serve a written notice that the matter will be taken up tomorrow.
Yes.
And have an endorsement to that effect, if possible.
I can send her through WhatsApp or email.
Whichever is possible.
Because she is not a regular
Achha.
advocate.
Whichever is possible. Take that. Next. Temporarily relieved from one. Temporarily relieved from one. In that matter, what is the charge which has to be paid?
They will assess, and we had, I think it has already been paid. Deposited that amount. It depends on the distance.
Distance. Srirampur.
Yes.
No, I don't
It
think
will be about
there is
250.
There's a ADJ, additional district judge in Srirampur.
Yes.
Yes, that is a subdivision. Because the distance between Srirampur and High Court is half of the distance between Chuchura and High Court. Nearly.
It is it will be 200 to 250 rupees.
You have If your client has been prompt enough to submit.
He
today
was
itself,
present today.
submit,
He
so
was present today, so there was no difficulty in that.
so the court in that circumstance presumes that there ought to be some document.
Yeah.
Nin. Okay. Learned counsels, kindly be seated. Let them press out the record. বান্ডেল থাকবে
জিও 226 জিও সেটা কনভার্ট yes
437 CO 437 of 2024. Yes.
Your Lordship, this is
In this matter, I am appearing for the Board of Work. I lead by Mr. Shalabdin.
this revisional application is from a judgment and order of the WAF tribunal. Your Lordship, first I filed a 226 application, writ petition.
Petition WPA 11136
That
of
was
23.
filed. Same matter. The Justice Sampath Sarkar held that no, you go before the revisional court.
The order of
So
the WAF
this
tribunal
application
under
was
challenge.
converted into 226.
The proper remedy of the petitioner would be to approach the said court. This writ petition is converted to an application under section 227 of the Code of Civil Procedure. Petitioner is under recovery to correct representation form. Being directed to enter the correction. Yes.
Now, Your Lordship, the notice board is appearing, but there are other respondents. Kolkata Municipal Corporation, CESC, and the police. This had a checkered career. Your Lordship, first I moved an application under 226, praying this relief which I sought in the application.
Oh, so you are representing only
The board of
respondent number 9. You are representing respondent number 9.
board of yes.
Board of
Number 9 and 10, my lord. I lead by Mr.
Executive.
Chief Executive
Executive
Officer.
Officer, my lord.
Representing both.
Minor senior has come, my lord.
Board of Work.
Seeing him, I thought he is representing the others.
No, he is for the board.
He is for the board. So what about the others?
Others has to be served.
Not served as yet.
No, because I served when I moved to 26 application.
WPA.
Your Lordship may admit this and I'll serve notice, let it come.
Okay. Let it be served first.
As Your Lordship may direct that, I'll serve. We have no problem for that.
My lord, in this matter, several irregularities has been done by the private respondents. And
Several-
proceeding has been initiated
Several irregularities have been done by
by the private respondents,
13 and 14.
Lordship.
And by the
Against this.
authorities also.
Against this.
Corporation, police, CSC, all have done it. Your Lordship, what happened, I'll say. Against these authorities, I moved an application under 226, writ. I prayed for reliefs against the corporation, police, and other authorities. The board came up and said that no, this is not maintainable under 226. You have to go for that relief. You have to go to the tribunal. I went to the tribunal. Tribunal allowed my application in part and rejected others, saying that I have no authority to order the KMC or the CSC. When I moved this Honorable High Court, they said the tribunal has a authority. And the tribunal says I can't pass any order against the corporation or the police or CSC. Your Lordship, I'm being made a shuttlecock. I came here for that relief. They sent me there.
So during the first round, they opposed.
Yes.
They said it will have to be preferred before
You
the
have to go to the trial for
Walk-off-
all relief.
walk-off tribunal.
I said that
When you approached the walk-off tribunal, they provided you part relief.
Yes.
Part was left aside
because
being beyond
we
their
don't
jurisdiction.
have the authority to order. Then why was my application under 226 set there?
My humble submission before your Lordship, my learned friend straightway came to the Honorable High Court. According to Section 83, first you have to go to the Work Tribunal. That was the submission of the Board of Work.
I went there.
It is the statutory provision.
That is the first step.
Yes. Lordship, they went to the Work Tribunal. Partly
Tribunal provided part relief.
Part relief got, and thereafter filed an application under 226.
Now under 227.
Yes, no. On that day, personally, the board, my submission that it will be converted to the civil division. Civil division. That was done.
It has been directed
Yes.
and it has been converted.
On that day, personally, I submitted before the Honorable Court to convert the writ petition to civil division. That was done by the Honorable High Court and the present revision.
But the problem is, why did you set if the tribunal
against the wrongdoer, the steps has been taken by the Board of Work by issuing section notice under section 54. It was Lordship reported to the police authority, corporation, everybody.
Your
Property involved is
of property burial ground.
No.
At
I want to know.
Kalighat, burial ground.
Burial ground has been
encroached upon,
and
buildings have been constructed without sanction. Suez connection is being given. All amenities are being provided without any relief.
And how many persons are residing there? How many families are
I don't know.
there?
It's countless.
A complex has been.
Yeah. Kalighat burial ground, Your Lordship, and it is declared heritage grade 1.
There is a mock also.
That has been vandalized. They don't take any
step. What doing in the inside of the mosque.
Everything. Vandalized, Your Lordship. Board is just sleeping over.
I am not against my learned friend's grievance. I am supporting him. As the Board of Work,
you are a neutral person. You are
Lordship.
No, they are the person to protect and preserve the property.
No, we have sent everything.
The reliction of duties they have done. I'll place that. Your Lordship, those are also on record.
Nothing more can be expressed from this end.
Yeah, see, Your Lordship, it's very sensitive matter.
Board has no any force. It is a problem. First problem. The board has no any force. That's why we have to depend upon the administrator. That has been done by the board.
No, it has not been done.
This is the
that is my grievance.
This is the Lordship's several order issued by the Board of Work.
Yes, let it be first. With regard to service, let it be regularized.
Never against my learned friend's grievance. Because it is the work property and we have to protect the same. Lordship.
Yes.
I am ready. AUQAF, AUQAF. This is the plural.
Yes,
HQF.
yes.
Thousand.
Now it is
No,
that.
no, it was WAKS, WAKFS, under amendment 2013. WAKS came AUQAF, that is plural version. AUQAF means plural version, and WAKF singular version. AF. Lordship, AUQAF. 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 Plural form.
We'll serve notice. Sometime in 2 weeks' time. It's okay. No, it's okay. I go.
না 27 না 27 এইতে মামলা আছে ইলাকে মামলা আছে 27 27 ও সরি 27 is old নেই 19 60 অবধি নেই 19 60 অবধি
1 minute. I'm checking my diary. 27 go back to item number 10. না 26
আছে
Yes, Lordship.
দিয়ে দিয়েছি তিনটে দিয়ে দিয়েছি
Grateful, Lordship. Number 10, Lordship.
Then, my lord, in this matter, yes. In this matter, learned advocate, Mr. Yes.
Not 1/4 purchase. It is out of 23, 15
State.
8.
4 legal acts.
Yes.
Anand.
Annoda. Perfectly recollected. My lord, so my lord, today I will say something about that 15. Not something, many things.
Before starting, my lord,
Because
in this matter, learned advocate Mr. Sushenjit Bonik is appearing on behalf of the opposite party.
আমি তো শেষ হবে না যে আমি বলি না
বলে আপনি বলবেন অবশ্যই
কোন সময় ধরলো? Now kindly come to page 23, the plaint. Paragraph 3. That subsequently at the lifetime of said another Prasad Jhali, though it is we disputing this contention that the land acquisition department, government of West Bengal, in connection with LA collector case number 28 of 1965-66 under the Act 2 1948 acquired about 15 decimals of land out of the said 23 decimals of land. That is a schedule of the shoot property situated on the northwest, south, west south and southwest part of a schedule shoot property from the said Annoda Prasad Jhali for the purpose of construction and or creation of PWD metal road running from Sarangi Pol Bazar to Manikpur Portala as shown in the rough sketch map. The said acquisition and requisition notice was duly sent in the name of Annoda Prasad Jhali, and the name was duly served upon him in connection with the said LAC case 28, such as by concerned department in due official course. Personally, well, we are disputing it because Annoda was no more at that material point of time. The said acquired about 15 decimals of land out of total 23 decimals, a schedule property, has been more particularly described in and or is hereinafter referred to as B schedule property mentioned below. My lord, skip it, my lord. 4. That thus, after the said acquisition and requisition, said Annoda Prasad Jhali at his lifetime till his death remained owner and possessor of the said remaining about 8. I missed the very vital point yesterday. For that reason, I submitted that 15 decimals is the main property. Yes, I am drawing your lordship attention. The former defendant, the club, I never heard of it that in a shoot under the nomenclature of partition. My lord, sorry. So number 4, that thus after my lord, first 2-3 paragraphs, my lord, it is very vital, man. That thus after the said acquisition requisition said Annoda Prasad Jhali at his lifetime till the death of remain owner position was said remaining about 8 decimals out of the land out of 23 of the land situated on east such and such, the said remaining 8 decimals of landed property has been more fully described and hereinafter referred to C schedule property. The said C schedule property is the portable property. I am going to submit before your lordship that is not remaining, because there are many things in that 15 decimals which will be evident from this plaint itself, which should be in the part and parcel of the partition process if at all required. If at all this shoot is maintainable, that should be the said C schedule property is the portable property of the instant suit which is required to be partitioned by meets and bounds only C schedule, they say. It's lawful amongst lawful co-sharer, the said C schedule property has been distinctly and specifically shown and or described, shown and delineated in color, such and such border in the rough sketch map annexed to the plane. The C schedule property is also part and parcel of A schedule property. It is correct. Number 5, it is pertinent to mention here as worthwhile I am disputing that the B schedule property which the plaintiff herein by cunningly under the influence of pro forma defendant get that 15 decimals out of hotspot of this partition suit, which some unauthorized person is enjoying, and that unauthorized person filed this suit through that legal layers of Annoda Prasad. Against the order of injunction, temporary injunction. No, injunction passed by the trial court. At entry, I am coming, my lord, I am just to read 2-3 paragraphs of the plaintiff. My lord, kindly see, my lord, that everything will be crystallized. If I able to show, yes, that is exactly true. But if I able to satisfy your lordships, that
Your lordship, kindly leave me, lord. One matter has been called.
তুমি যাও না. My lord, if I able to show that the suit was filed malafidely, maliciously, and misconceivably, the suit is not maintainable. Why should I? Why, my lord, definitely. Why? No, not that. Yesterday, yes, filed by myself only, not the other. There, my lord, to satisfy your lordships, if the suit is at all maintainable, and what is the purpose behind this suit, whether it is for the co-share or partition or something else. My lord, 2-3 paragraphs, it will be clear. Yes, my lord, yes. Paragraph 5. It is pertinent to mention here as worthwhile to maybe mention this context that though in the said LA case 28 such and such, the land acquisition department acquired B schedule portion 15 decimals of land out of the entire 23 decimals of land, that is A schedule suit property as stated herein above, but for the purpose of construction, my lord, kindly see, for the purpose of construction creation of the said PWD metal road, only a very meager part of the said acquired 15 decimals of land was practically utilized, and the rest portion, now what is rest portion remain unused. So, my lord, under the acquisition law, the portion which is not required, which has not been consumed, it will be, my lord, de-acquisition. It will go back to the original owner. My lord, we have not received any compensation. That is not lawfully, that was not acquired even. My lord, I am coming now, my lord. See, the next sentence. The Sarenga Uttarpara Barwari Durga Puja Committee, that is the present pro forma defendant number 32, through its office bearers, members, and also villagers, that is people of large, the large of the locality since time immemorial, that is even since before acquisition, have had been using, occupying and possessing the entire remaining said B schedule land. Entire remaining. That means that will be not less than 14 decimals. Land. For which purpose? B schedule land, that is the portion remaining after construction of road peacefully, continuously and uninterruptedly for the purpose of holding. Now, what activity is going on? Holding Durga Puja, other religious festivals, social cultural functions, weekly haat. Weekly haat never happened without any rent. Weekly haat of different commodities, school sports, carnival, food stalls, shops on the said land and their other adjacent landed properties to the knowledge and everybody of the locality, the said B schedule property as shown in the green border. So, my lord, out of 15, a meager portion gone. A meager portion means it must not be more than 1 decimal. It is not specified, but the
court cannot assume.
Yeah, as not as, but the sentence goes on suggesting a meager, very meager. It is not my creation. A very meager. That means, my lord, that means, my lord. So out of 15, if we constitute this very meager, that must be
maybe something very small quantity.
More portion is lying unused. Most of the portion. So most of the portion who are there? Barwari Puja Committee come into existence. Villagers come into existence. My lord, heart is going on. My lord, cultural function. My lord, religious festival, school sports, carnival, food stalls, shops, land and their other adjacent land. So stalls, shops, it is not going on without any rent. So who is collecting the rent? No answer. So this claim must not be expected from the co-owner, from the legal heirs of Annoda Prasad Dhali. I am entitled. I filing the suit for partition. We ourselves has been, my lord, excluded from our rightful, my lord, position, our rightful authority. So it is whose benefit? This portion only I am drawing your lordship's kind attention. Paragraph number 5 of the plain. It is I am putting question to myself. Is it the benefit of the plaintiff or the legal heirs other than the son of the Annoda Prasad Dhali? Is it at all?
When you are putting that question to yourself,
to myself,
and
to myself,
court is putting question to itself only.
My lord,
does the court have the jurisdiction to entertain these submissions?
No.
We are hearing first appeal, second appeal, or civil revision.
But my lord, I wanted to satisfy your lordships. Why my client should unnecessarily suffers order of status quo or injunction, something like that? Why? And why the plaintiff?
You want to place the intention of the plaintiff.
Intention of plaintiff, and the suit is not maintainable. Suit is under section 34 of the Specific Relief Act. Order 2, Rule 2. My Annoda Prasad died 1955. So, my lord, can you see 34 what say?
Learned counsel,
your lordship
have you
well aware of 34, section 34 Specific Relief Act.
Have you filed any application to in that regard?
My lord,
there is provision.
My lord, I don't know what happened there. I don't know, but written statement.
The court will know.
No, certainly not.
Then
So, my lord,
we are confined within the
whether
impugned order.
whether it was rightly passed.
Yes.
So your
That
lordship,
is to be
yes.
taken into consideration.
So unless my lord, from the plaint itself, that this suit is not at all partition suit. The suit, the main relief has been, my lord, main relief has been, my lord, something, my lord, left out. Main relief. Why, my lord, why only C schedule is a portable one? Why not the rest of 15 decimals after, my lord, utilization portion? Why that portion will go?
So you have preferred this revision against the judgment passed in the misappeal.
Yes, misappeal. Misappeal. And wherein I have been injuncted. And, my lord, injunction, that status order was not clear. My lord, I show one judgment of the Honorable Court, Supreme Court, that status quo, what sort of status quo, that should be there. I am placing that order impugned.
Status quo in respect of the nature, character, and possession of the suit property.
I am placing that. Even, and also the final injunction order. I have with that final order of the trial court. So, my lord, kindly few paragraphs of this plain.
Please.
So, my lord, the said Barwadi Durga Puja committee, my lord, I am reading, my lord, paragraph, page 25.
25, middle portion.
6th line from the bottom, top from the bottom.
You have
6,
reached,
7.
you have reached up to occupying and possessing the entire remaining said
Yes.
B schedule portion.
B
That is
schedule, property as shown in the green border
remaining
in
after
the said draft sketch map.
That is the portion remaining after construction of the road.
Road.
Peacefully.
Yes. Draft sketch map has got no nexus with C schedule property. As shown in the red border in the annexed draft sketch map, the said Barwadi Durga Puja committee had been using, enjoying, and physically possessing the B schedule property. So, a person was made pro forma defendant. So, what would be the nature of the pro forma defendant? No relief was claimed against the pro forma defendant. But here, pro forma defendant, they, my lord, certify, or they are praying a declaration in the form the plaint was drafted, that they are in the position without interruption from anybody, including the reyards of Arnoda Prasad. This is that. So we know
where it is mentioned that the pro forma respondents.
Yes, a Durga Puja.
The plaint.
Yes. That is a Barwadi Durga Puja committee.
Place the prayer portion.
My lord, here, what is the assertion? Here, assertion is 15 decimals after acquisition process, after construction of PWD road, entire balance 15 decimals of land, which is the part and portion of the B schedule property, that is under the position of that Barwadi Puja committee. Barwadi Puja committee. So, it is from in the mouth of plaintiff, who is not the Barwadi Puja committee. Plaintiff is our co-sharer. So plaintiff could not assert this sort of assertion, excluding them.
Plaintiff or plaintiffs?
Plaintiffs.
Plaintiffs, along with the pro forma, are hand in gloves.
Yes. I have said judgment that if in that event, my lord, what is the your lordship knows better than me that pro forma defendant, if figure in a suit, in any suit, that plaintiff made an my lord averment that no relief has been claimed against the pro forma defendant. But in a suit, if it is evident that pro forma defendant, in order to gain or receive any advantage, they file this suit, there is the advantage will go to the pro forma defendant. That means he no longer remain as pro forma defendant. My lord, kindly visualize my contention, my lord, whether I am right or wrong. Here, this contention that as shown in the red border, the schedule rough sketch may the said
your-
Barwadi Durga Puja committee.
Mr. Daspoddar, after your submission,
lord.
the court is having a panoramic view. Yes,
We
you can,
expect that.
you can continue.
Durga Puja committee had been using, enjoying, and physically possessing the said schedule property even since the lifetime of Annoda Prasad Dhali within his full notice, knowledge, consent, approval, acquisitions, willingness, acquiescence, willingness, ratification, etc. All these adjectives, all in favor of Barwadi Club. In all respect and without any sort of objection, obstruction from his end in any manner whatsoever in a material time, just like a claim of adverse possession against the true owner. Thus, from the above, it is crystal clear that those said Annoda Prasad Dhali originally was the sole absolute and exclusive owner and possessor of the entire schedule property, schedule shoot property which consists of B and C schedule, that property. But after acquisition of B schedule shoot property by the land acquisition department in the above manner at his lifetime, said Annoda Prasad Dhali till his death seized and possessed only C schedule property. Though Annoda Prasad died sometime in 1955, the genealogical table which suggests the date, it is not true. It is concocted one. Annoda Prasad Dhali died sometime in 1955. So at that point of time, daughters having no right to be inherited. It is July 1956. After July 1956, if any Hindu male died, then in that event, my lord, his daughter will come into the inheritance of his property. Well, it is 1955. Here, in every sentence, every paragraph, it was given to an impression that Annoda Prasad Dhali died sometime in 70. So, acquisition notice was served upon him personally. No proof against that. No compensation. And
You had contested. You had contested the temporary injunction.
Yes, it is.
You had preferred the miscellaneous appeal.
Yes. No dispute.
Therein, you had raised this issue as regards to the death of Annoda Dhali.
My lord, that would be my lord, at the trial stage, my lord. Unless the trial is come, my lord, and written statement is disputed.
When this question is put to you, say that
No,
will be decided in the trial stage.
It is disputed in written statement. Written statement disputed. Property by land. Now, paragraph 7. That ultimately, while retaining, seizing, and possessing his said remaining 8 decimals of shoot plot, only the C schedule shoot property of Annoda Prasad Dhali died intestate sometime in the year 1970, leaving behind him his one son, namely Gunodar Dhali, or 3 married daughters, such and such. This is that about the married daughters. 8. That out of that set 4 brothers and sisters, Simoti Jurabala alias Juramani, Gayan died intestate first sometime in the year 1976. Her daughter died 76. Daughter. Annoda's daughter died 76.
Lord Counsel, place the written objection against the injunction application.
Injunction application.
Your written objection.
Page 72.
Page 72.
The theme covered, yes.
72 Alex D.
My lord, in a plaint, my lord.
In which paragraph you have agitated this one about the date of death or year of death of Annoda Dhali?
First, your lordship, there will get it from the written statement.
Yes. No.
Written statement.
You place from the written objection only. It obviously it will be mentioned in the written objection. There won't be any much difference between the written statement and the written objection.
Come to paragraph, page 73, paragraph 9. That the statement made in paragraph 2, subrule 2 of injunction petition totally matters so well known to the plaintiff and proved strictly by the plaintiff that originally said entire A schedule property belonged to Annada Prasad Dhali, son of Pokit Dhali, had owing to possessing, enjoying, occupying his said property peacefully, continuously, by exercising all acts of ownership possession there without any objection, obstruction from any corner in any manner whatsoever. It is about the knowledge that club is Barwadi Puja is in possession of the land or holding the puja. That paragraph 10, that the statement made in para 2, 3 injunction petition is totally matters so well known to the plaintiff and to prove strictly by plaintiff. Subsequently at the lifetime of said Annada Prasad Dhali, the land acquisition department, government of West Bengal in connection with
Council till paragraph 29, page 80. You have denied each and everything.
Yes.
Thereafter, in paragraph 30, you have placed whatever has to be placed by the defendants or the opposite parties here in the petitioners. Go through the place the paragraph 30, page 81. That the facts of this instant suit in nutshell is that
the above
you can
have been unnecessary.
you are unable to read.
Huh?
You are unable to read.
My lord, it is from
What has been provided to you, or it is a preparation of yours.
My lord, let me first, my lord, place the written statement where that portion, the paragraph that about the date of 1970 that I disputed. My lord, kindly see written statement. I am coming to take you and I am coming back very soon. My lord, this is paragraph 7. My lord, so my lord, written statement, it is paragraph 16, that statement made in paragraph 7 of the plaintiff matters well known to the plaintiff and to prove strictly by the plaintiff that ultimately while retaining, seizing and possessing his said remaining 8 decimals of the shoot plot, that is only C scheduled shoot property, said Annada Prasad Dhali died intestate sometime in 1970, leaving behind him his one son, namely Gunadhar Dhali, and 3 daughters. My lord, I disputed that. My lord, kindly have a look, my lord. British
Yes.
is not with
Yes.
paragraph
It was-
7.
Written statement has not been provided.
No, it is the annexure
Achi?
of the civil division.
Photo?
Page 75, my learned friend is referring the
Page-
paragraph number 15, which is appearing in page 75.
হ্যাঁ,
কি বলছো?
ওটা written objection.
Written objection ও দিয়েছো তুমি?
Written statement.
Statement ও আছে?
written statement ও আছে, written objection আছে।
আছে ওখানে? Is হয়ে গেছে। My lord, kindly see written statement, paragraph 16.
Which page is the written statement?
25.
75?
75.
No, that is the objection, written objection to the,
মিস হয়ে গেছে তাহলে ওটাই
that is the objection,
yes
written objection against the application under order 39 rule 1 and 2.
well kindly read it my lord.
What can you say better than this one?
Written statement was not there, it is not in my file. More precisely mentioning the even year 1970. But the plaintiff will stick proof thereof. Because my lord, kindly consider, I am the my lord second purchaser. First property transferred 2015. Then from the purchaser, my client purchased in 23. I have no relation with the family.
Yes, in paragraph 14, you were referring to paragraph 14.
16.
16.
16 of written statement.
That the statement made in
paragraph 7.
Yes, the statement made in paragraph 7 of the plaint matter well known to the plaintiffs and to prove strictly by the plaintiff that ultimately while retaining, seizing and possessing his said remaining 8 decimals in the suit plot, that is only the scheduled property, said Annoda Prasad Dhali died intestate sometimes in the year 1970, leaving behind him his own one son, namely Gunodhar Dhali,
and 3 daughters.
Now deceased, and 3 daughters, namely Bojobala, Bachar, Jurabala, as his only legal heirs and successors who jointly inherited this scheduled property from their said deceased father in equal share, that is having undivided 1/4 share equivalent to above undivided 2 decimals therein, and the wife of Sir Honorable Dhali predeceased him, hence denied it categorically, and the plaintiffs are hereby asked to strictest proof thereof.
So the
what
figure,
you have stated here,
so
you have only denied everything. Have the defendants stated anything herein? The entire paragraph is denial of paragraph 7 of the plaint.
That should
Paragraph 17. Paragraph 17 is the statement made in para number 8 of the plaint matter well, it has been laid down, paragraph 8 of the plaint. Thereafter, hence denied it categorically. Obviously, that will be the written statement.
Written statement is
Denial.
expected. That written statement expected from the legal heirs of my lord Annoda Prasad.
Whatever
I am.
Whatever you have to say or you had to say will be mentioned after the denial.
Positive assertion.
Yes. That I was referring that in.
I got your lordship's point, but my lord, kindly read, my lord.
In paragraph 30 of the written objection.
My lord, your lordship is correct. But my contention,
why are you placing the denial?
Who is my client? He is not the piece and parcel of Dhali family. He
has purchased from the son of Dhali, Annoda Dhali.
No. He purchased from Biren Hati. Biren Hati
purchased from
the legal heirs of
son of Annoda Dhali.
Yes. So, my lord, I am the distant purchaser, my lord. So, my lord, it is not. It is expected.
What will be the difference?
It is expected from other defendants who are the legal heirs of other 3 daughters. There is no other written statement. There is no other written statement.
No. You have raised the point that Annoda Dhali has expired prior to the coming into force of 1956.
My lord, first thing.
As regards to inheritance, Learned Counsel, if you want to have that point taken into consideration by the court, then you shall have to assert through something. Have you provided anything that Annoda expired prior to 1956? As such, the 3 daughters were not entitled?
No.
So
it is first. It is must. It is my first defense. Second is my lord. Why, my lord? Only 8? Why only C schedule? What about the remaining of 15 decimals? After my lord, consumption of the state for construction of PW road, why this property will not come for consideration of partition? If 1955 goes, if 1955 goes, then it will come. That why only 8? Why the plaintiff, who is the legal heirs of one of the 3 daughters of Annoda Prasad Dhali, while they excluded themselves from claiming that right over that property, that 15 decimals or little less than 15 decimals? Why that would not be come? So partition should be filed in respect of entire property left out by predecessor. It is directly hit under section 34 of the Specific Relief Act. And why the plaintiff files the suit for partition?
That will be agitated in the civil revision.
My lord, I am only want to satisfy your lordships that the order of injunction injuncting me only C schedule property which comprised of 8 decimals of land left out by Annoda Prasad Dhali, and where entire 8 decimals is covered by a 2-storied building constructed by Biren Hati, 2015. 2015, that deed was executed, wherein one witness was there who happens to be the husband of the present plaintiff. 15, they challenge in the suit. First thing, they claim they are the club's right through plaintiff. Club have every right. Club is possessing with full knowledge of the legal heirs of Annoda Prasad Dhali. Club asserting their possession as rightful one. First. Secondly, my lord, the 15 decimals, the plaintiff of a partition suit, never, it is unheard of that they themselves excluded their right over some of the property. If that be so, in that event, the section 34 will comes into effect, comes into picture. Ultimately, suit will fail. This is the thing. For that reason, I am not.
Mr.
Yes,
Poddar, what right do you have?
I am the
property.
I am the rightful purchaser for consideration. Rightful consideration.
You have the right over that portion of the property which you have purchased.
Yes. Absolutely correct.
From Mr. Hati.
Absolutely.
Who purchased it from the legal heirs
Biren Hati.
Who purchased it from the legal heirs of Anando Doloi?
No, legal. Yes. Son of.
Doloi.
Yes. Yes.
Apart from that portion,
I have no interest. I have no interest. For that reason, I suggested, I prayed before your lordships, my lord, some repairing works is urgently required.
After
admitting.
After half an hour.
After
half an hour. Yesterday we had reached to that point.
Yes.
Yesterday we had reached to that point.
Yes.
Today half an hour gone.
The matter was admitted 6-8 months back. My lord, I have forgotten, my lord. Yesterday I read entire plaint, my lord. Entire injunction, order of injunction. My lord.
So you are taking the opportunity to read out the entire written statement.
No, not written statement. Entire plaint. That what about 15 decimals? Why 15 decimals? My lord, set aside from the picture of partition.
Now let us come to the crux.
My lord. So, my lord, firstly, my lord,
Mr. Poddar, you will get up till 4:30, not any further time.
My lord,
yes.
My lord.
No. You have
your lordship never possess such threat to us, my lord.
You have utilized half an hour today,
my lord,
without any fruitful
result. Because my lord, kindly see, my lord, bona fide purchaser, my client, who is a bona fide purchaser, he is suffering, my lord.
You have been You have been
my
restrained.
lord, my lord, just
You have been restrained from alienating.
no, no, no,
Alienating, no?
my lord, my lord, I am coming, my lord, my lord, I am coming, my lord, your lordships wanted that order of the final judgment of the court below, trial court. My lord, I am placing that, my lord. আরে দেখো ক্লার্ক দিলে একটাই ছাত্র আমি জজ সাহেবকে দিতে পারছি না 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 আমি আমি দিয়ে দিচ্ছি তুমি তো কালকে বলবে দাঁড়াও My lord, my lord, it is 20th September 2024. My lord, I'm sorry, I will hand over it after my reading, my lord. Today is
Grateful.
fixed for.
Grateful.
I'm sorry. I'm sorry, my lord. This is my mistake of my. Hazir have been filed. An application under section 148, read with section 151 of CPC is supported by affidavit for extension of ad interim order of injunction dated 4/4/23 has been filed today by the plaintiff. The case is taken up for passing order. Peruse the plaint and application under order 13 rule 1 and 2, read with section 151 of the CPC dated 4/4/23 filed by the plaintiff. Written objection dated 12 December 2023 filed on behalf of the defendant number 1 and 2. Counter affidavit dated 12/9/23 filed by the plaintiff. Document filed on behalf of the both sides and other materials available on record considered. It appears from the plaint and application that the Schedule C mentioned suit property is an undivided property and both plaintiff and defendant are co-sharers in respect of the same. Not 15 decimal, we are not co-sharer. Only this 8. Very well. The plaintiffs through plaintiff number 3 on 1st April 2023 asks the defendant number 1 and 2 for effecting amicable partition of the Schedule C mentioned suit property, only Schedule C by meets and bounds according to the respective shares, but the defendant number 1 and 2 not only flatly refused to make such partition but also openly and violently denied the title of the plaintiffs over the Schedule C mentioned suit property. The said defendants also made attempt to raise new construction on the entire Schedule C mentioned property and also tried to change nature and character of the same. The plaintiff have thus filed present application.
These two sentences once again. These last two sentences.
Yes, the said defendants also made attempt to raise new construction. It is 2 stories building.
hand over
আছে এটা হ্যাঁ দিয়ে দাও না তাহলে তো ভালো হয়
সরি মাই লর্ড
ঠিক আছে ঠিক আছে I am grateful to my learned friend, my lord. One second, my lord.
What was to be performed by you is being performed by your adversary.
Because they are representing the club. 15 decimals, my lord.
Yes, the said defendant
also made attempt to raise new construction on the entire C schedule. Well, I don't got the meaning of this sentence. There was a 2-story building on C schedule land. And here, the said defendant also made attempt to raise new construction on the entire C schedule. Entire C schedule.
C schedule refers to
808 decimals. And there was a 2-story brick building. And here it is, if it is that and a part of the C schedule, that can be accepted. Here it says that entire schedule C. That means again 08 decimals of land. What form it is coming? What from the learned trial judge got it?
Yes.
I am coming with the judgment, the status, what the order of status quo should speak. It should be clear speaking status quo.
Yes.
What sort of status quo? I have one judgment of Supreme Court. I will refer it. And also tried to change the nature and character of the same. The plaintiff have thus filed the present application and prayed for relief. The defendant number 1 and 2, on the other hand, contested the temporary injunction application. No other, only defendant number 1 and 2. Application by filing their written objection, thereby denying the allegations made by the plaintiff in their application for temporary injunction. The defendant number 1 and 2 have categorically stated that they have purchased the suit property by virtue of a registered sale deed being number such and such for the year 2023 on 6th March 2023 from one Biren Hati, and since then they have been in possession of the suit property. The defendant have also mutated their names in the ROR and have been paying khajna and panchayat tax in respect of the suit property. Originally, the property belonged to the predecessor of Gunodhar Dhali, and after the death of predecessor, said Gunodhar Dhali became the exclusive and recorded owner in respect of the suit property. Gunodhar Dhali died intestate, and after the demise of Gunodhar Dhali, his legal heirs become the joint absolute owners, occupiers, and possessors in respect of suit property. Suit property means only C schedule. Legal heirs of Gunodhar Dhali transferred their right title interest in respect of the suit property in favor of Biren Dhati by virtue of registered sale deed such and such of year for the year 2015 on 27 November 2015. After a long period on and from the year 2015 to 2023, the absolute owners are in possession of the suit property, and none of the persons, including plaintiffs, made any obstruction, and or create any disturbance towards the previous and present owners of the suit property over the suit property in any manner. The husband of the plaintiff number 1 and the father of the plaintiff number 2 and 3 were physically present. My lord, kindly see, my lord. Husband of the plaintiff number 1 and the father of the plaintiff number 2 and 3 were physically present and duly signed over the sale deed of conveyance as a witness in the presence of other witnesses. Therefore, the plaintiff have got every knowledge in respect of the said deed, which was duly executed at the house of its vendor through commission work by the authority concerned, which has been totally suppressed by the plaintiff in this suit. Mala learned judge took this point. The plaintiff have never been possession of this suit property, and they are illegally demanding the share of the defendants, which is absolutely belong to the defendant number 1 and 2. The plaintiff have no right, title, interest over the suit property in any manner whatsoever. The defendant number 1 have prayed for dismissal of the temporary injunction application filed by the plaintiff with cost. It appears from the written objection that the defendant number 1 and 2 have stated that the suit property originally belonged to predecessor of Gunodhar Dhali, and after the death of predecessor, said Gunodhar Dhali became the exclusive sole recorded owner in respect of the suit property. Subsequently, the legal heirs of Gunodhar Dhali transferred their right, title, interest over the suit property in favor of Biren Dhati by virtue of registered deed of sale being now such and such for the year 2015, dated 27 November 2015, and the said Biren Dhati subsequently transferred the suit property in favor of present defendant by virtue of a registered deed of sale over the year 2023, dated 6 March 2023 by meets and bound. It has also been stated by the defendant number 1 and 2 that entire property measuring 8 decimals was well amicably settled and defendant settled by between all the co-sharers and legal heirs and successors who were exclusive owners and occupiers and possessors as per the record of rights from the copy of the registered deed of sale being such and such 2015. It is not revealing that said Gunodhar Dhali was the exclusive owner of the suit property, and it is also not revealing that the suit property has been partitioned amongst all the co-sharers by meets and bound. Whereas from the plaint as well as from the injunction application, it obviously appeared that the suit property was originally belonged to Annodha Prasad Dhali, who died 1970, leaving behind 3 daughters, 1 son, Gunodhar, namely Gunodhar Dhali, his legal heirs and successors. The defendant number 1 and 2 claiming their absolute right and interest over the suit property could not prima facie establish that suit property was partitioned by meets and bound amongst all co-sharers of that property purchased by them was actually well demarcated property of Gunodhar Dhali. Considering the claim of the counterclaim of respective parties, the court is of considered view that the Schedule C mentioned suit property is required to be preserved in its status quo till disposal of the suit. Ordered that application under 39 Rule 1 and 2 reduce section 150 on CPC 4420 dated 4423 filed by plaintiff is hereby allowed on contest against the defendant number 1 to but without any order of cost. Both plaintiffs and defendant number 1 and 2 are hereby directed to maintain status quo in respect of nature, character, position of the suit property till disposal of suit. So, my lord, here my lord ordered, my lord, directing status quo to be maintained by both parties in respect of possession,
nature and character,
natural status quo in respect of nature and character and position. So, I will firstly, my lord, here this order the flaws is this, illegality is this, only C schedule was considered. There is no B schedule. 15 goes. Number 2, my lord, that status quo order must be specific. In which respect, what is status quo? Status quo term is a vague term time and again. Different High Court, including Supreme Court, criticize this word, that the court by saying or by ordering the parties to maintain status quo, it is not suffice. The person, they are interpreting according to their own whims and capsize. So status quo should be more particularly, precisely, it should be indicated. Otherwise, that order is not tenable. And my contention, main contention, my lord, if 15 plus 8, your lordship just suggested that I have no more right than 08. So if 08 is excluded, I have no problem. I will retire from this suit. But since 08, the title, the deed has been challenged after lapse of 3 years. After lapse of 15 and 23, 8 years, 3 years is limitation. So in no circumstances, under no stage of imagination, by filing any application under section 5, this defect can be cured. A suit for cancellation of sale deed must be made, and it is knowledge and consent is there, must be made within 3 years. I have purchased from a first purchaser. I am not the first purchaser. I am the second purchaser. There was no suit, no proceeding from 15 to 2018. So their right has been waived, if at all there is any right of the legal heirs of the Annoda Prasad Dhali. I mean to say the excluded 3 daughters and their successor in interest. They have waived their right. They stopped from challenging the or praying for partition over 08 decimals of land, because party transfer took place in 2015 in broad daylight, knowing and known to everyone of the Annoda Prasad Dhali. All the legal, it is known to the Annoda Prasad Dhalis. So why 2015 deed has been challenged in 2023? It is question to myself. So that can, in the guise of partition suit, they can't challenge it. And in that partition suit even, my lord, it is a partition suit where the co-sharer themselves excluded or they are relinquished their major right in favor of some stranger persons or stranger body. So it is for whose welfare this suit has been filed.
A decree for declaration that the registered deeds,
Yes, 5 schedule D.
No, not schedule. I'm referring to the
What your lordship?
prayer portion.
Prayer,
portion.
my lord.
First prayer.
Yes.
Page 38.
Yes. 38.
First prayer.
First prayer.
A decree for declaration that the registered deeds of conveyance as described in item numbers 1 and 2 in the D schedule below to the plaintiff are illegal, void, fraudulent, invalid, baseless, and not binding upon the plaintiffs as well as upon the defendants.
Number 9 to 31.
9 to 31. The item numbers 1 and 2 refers to, in the second line,
D. Here, yes, conveyance as described in item number 1 and 2 in the D schedule.
Registered deeds of conveyance.
Yes.
I think there's
2 deeds.
more
15
than one,
deeds,
more than
yes,
one.
and my client's deed. So, my lord, in my lord partition suit, we usually
Partition means that of Hathi.
Biren Hathi. So my lord, Biren Hathi's deed, my lord, 2015 deeds, they are coming to challenge, my lord, and it is the first prayer. Usually in first prayer in partition suit we find declaration of share and preliminary decree.
You had purchased in which year?
23.
No, you have purchased.
I have purchased
2023.
2023.
2023.
Yes, it is annexed. Yes, it is page, my lord, 84.
So it is
23, March 83, March 6 March 2023. So, my lord, from this, it is a legal point, my lord. I can raise this point, whether that the suit is maintainable at all. If the suit is not maintainable, then what for this interim order? What for this injunction? If for that this is order 7 rule 11, my client ought to have present on order 7 rule 11 of the Code of Civil Procedure, my lord, before my lord hearing of injunction application. Anyway, that can't be, I can't, I have no opportunity.
No, you cannot say anyway.
But thing is,
Each and
but
every,
prayer is
there is procedure laid down.
My lord,
each and every step.
My lord, that but my lord, that is
what you are seeking.
Yes. So
you have suggested.
I missed it. Even now it can be filed. That is no problem.
Not missed.
But my lord, kindly see what your lordships have gone through several prayer of partition suit. First prayer usually, my lord, preliminary decree. My lord, so this prayer at whose behest? This prayer and excluding 15 at whose behest? So answer will be at the behest of pro forma. So what is the definition of pro forma? Who has no forma? Who has no benefit? But here it is the main beneficiary is pro forma defendant.
You place the citation. You place the citation.
Regarding this.
What do you intend to place?
Something. I will conclude my argument by showing that relying the judgment.
You have completed your submission. Cite the authority.
My lord, kindly, my lord, come prayer one by one, my lord. So more we read, so more we can be able to ascertain the mischievous intention of the pro forma defendant. It is not for the welfare of my the Gunodhar Dhali's daughter's legal heirs. Certainly not. But in a partition suit, why, my lord? It is question to myself. Why the major portion? It is admittedly it is.
Whatever had to be pleaded, you have pleaded.
Yes. Pleading is over. Now proofing before the court below.
Whatever was required to be submitted, you have submitted. Now you place the authority. Authority, not authorities. Not authorities. Place the authority.
Only three. Only three. First, my lord, I am reading, my lord, 3 lines from 34. My lord, 34, my lord, says, my lord, a specific relief act, my lord. This, my lord, specific relief act 34.
Specific relief act. Specific relief act. Specific relief act. Specific relief act. এটা খুলে কিনা একটু নেটটা কানেক্ট করে দিন তো একটু।
ম্যাডাম ডাকছি।
নেটটা একটু কানেক্ট করে দিন তো, নেটটা একটু কানেক্ট করে দিন। Yes, you please.
Section 34.
Hmm.
Discretion of court as to declaration of status or rights.
Hmm.
Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Whatever relief he prayed for, he must be they must be limited themselves from this suit, no further, provided that no court.
A person has to seek the reliefs which he is entitled to have.
And the plaintiff need not in such suit ask for any further relief. Whatever relief he is entitled to at the said material point of time, he should ask for its entirety. The meaning is that, provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. So, here, my lord, first pair is declaration. First pair is declaration. And the following other pairs are all, my lord, confined to 8 decimals. Admittedly, another left behind 23 decimals of land during his lifetime. Any acquisition after his lifetime, that is a meager portion of 15. And admittedly, the plaintiff suggests that from that B schedule, that is from that 15 decimals, a big playground, where Durga Puja Utsav, Durgotsav is held by the local Barwari Puja committee. My lord, Hart, my lord, carnival, shop, and many others activities are going on.
Section 34 placed.
So, my lord, the beneficiary must be the parties other than that pro forma defendant, according to their contention. Yeah, we are all heirs of legal heirs of Annoda Prasad Dhali. So why these persons, local villagers, club, school playground, why? I am putting question to myself. The beneficiary, Annoda Prasad, left the property for the welfare of his legal heirs, not club, or he donated it. So that was left out. The more benefit wherefrom accrues in favor of the parties, in favor of the legal heirs of the Annoda Prasad Dhali, that has been left out. So it squarely hits the proviso of section 34. If a suit,
Next point, Mr. Poddar,
hits the proviso, then in that suit, my lord, though that order of injunction is not tenable, is no leg to stand, not sustainable at all in the eye of law. Now, my lord, kindly say order to rule 2 of Code of Civil Procedure.
Thank you.
Suit to include the whole claim. Suit to include the whole claim. My lord, may I disturb your lordship? Then, my lord, I am coming tomorrow at 10:30, no problem.
We can continue.
My lord. Suit,
if not released.
এটা আবার জিজ্ঞেস করতে হয় নাকি? এটা আবার জিজ্ঞেস করতে হয়। Every should, order to rule 2, should to include the whole claim.
Lord Senior Counsel, you can leave. Because it is 4:30, we will continue with this matter only. It is 4:30. Mr. Poddar, let us conclude your part today.
If time permits.
The current player may pick one thing. No, you lot is making it next Wednesday. That will be very convenient because today I cannot go to any doctors or otherwise.
No, I couldn't get you.
কালকে রাখবেন না।
What
কালকে ছেড়ে। কালকে ছেড়ে।
What you are seeking?
Leaving tomorrow.
Oh,
বলুন।
except tomorrow. Except tomorrow.
Yes, yes.
You will also take it up on Wednesday next. That will be convenient.
Next Wednesday.
Lord Senior Counsel, it will be better
I have to.
when it will be done, but not in the absence of the other side. When the matter is called, when the matter is called, let there be someone to seek.
But there is no other statement. I will do it after we just fine.
So when the matter is called, let there be someone to seek accommodation. Yes. 34 complete. Order to rule 2.
Order to rule 2. Should to include the whole claim.
Yes.
Every should shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But a plaintiff may relinquish any
Part of
portion,
claim.
any portion of his claim in order to bring the suit within the jurisdiction, within the jurisdiction part. It is not that case. So it is rule 2, order to rule 2. Now, my lord, kindly see, claim of absolute estate by widow or female heirs prior to 1956.
Life estate.
Yes. When a male Hindu dies possessed of property after coming into force of the Hindu Succession Act, his heirs as per the schedule take it in terms of section 8 of the Act. The heir or heirs take it absolutely. There is no question of any limited estate descending to the heir or heirs. Therefore, when a male Hindu dies after 17th June 1956, so my client died as per
your client.
Huh? So as per instruction of my client, predecessor, not my client's predecessor, my client's vendor's predecessor. So distance, if it is my predecessor, certainly I will come up with a death certificate. The predicament is there. So, because my lord, yesterday
the third issue which you have raised,
yes, yesterday
that is not in contention.
Yesterday, my lord, I got hold from this file one handwritten, my lord, instruction. Here, my lord, I got it.
With yourself.
Here I got it that অন্নদা প্রসাদ ঢালি মারা গেছেন 1955 বাংলায় 1361, গুণধর ঢালি মারা গেছেন 6/8/2000. It's all written.
That is gospel truth.
No, no.
6/8/2000
6/8/2008
2015 ডিগ্রি এটা করলো কি বলে ডেটটা
কোনটা
তোমার ভেন্ডারকে
আরে গুণধর ঢালি
তো তোমার ভেন্ডার
গুণধর ঢালি দিয়েছে নাকি গুণধর ঢালি বউ ছেলে মেয়েরা দিয়েছে কি বলছো আমরা অত ভুল করতে ভুল মাঝে মাঝে হতে পারে কিন্তু অত ভুল হয় নাও মাই লর্ড কোনটা হ্যাঁ মাই লর্ড
Yes, next point.
10:30.
Tomorrow
10:30.
Section 34 SR Act.
It will take my lord at least half an hour time. My lord, see judgment are there. My lord, I have to place it. My lord, I am giving it. My lord, tomorrow I'll refer it. My lord. Otherwise, my lord, tomorrow for me, my lord.
This, this is not, this is not
But
being
today I
appreciated.
expected, my lord, it was 3, item number 3. I got ready in that. I was the time of my lord when I lifting. I asked your officer that our matter is placed 10. My lord instructed it is at 3.
একটু বন্ধ করুন তো, বন্ধ করুন তো। Who was